candidates. 2. The learned counsel for the appellant states that disqualification is for life by relying on the decision in the case of Samiullah Baloch versus Abdul Karim Nashirwani, PLD 2018, Supreme Court 405, which held that when Article 62(1)(f) of the Constitution of the Islamic Republic of Pakistan is retracted, the disqualification is for. However, the learned counsel for the respondent in civil appeal number 981 and 985 of 2018 dismisses and states that the period of disqualification is for 5 years as per Section 232(2) of the Elections Act 2017, which provision was enacted through the Elections Amendment Act 2023, promulgated on 26 June as per Section 232(2) of the Elections Act 2017, which provision was enacted through the Elections Amendment Act 2023, promulgated on 26 June 2023. The learned Additional Attorney General also relies on the said statutory provision reproduced hereunder. 232(2). Notwithstanding anything contained in any other provisions of this Act and other law for the time being in force and judgment, order or decree of any court, including the Supreme Court and a High Court, the disqualification of a person to be elected, chosen or to remain as a member of the Parliament, Majlis-e-Shura Parliament or a Provincial Assembly under paragraph F of clause 1 of Article 62 of the Constitution shall be for a period not exceeding 5 years from the declaration by the Court of Law in that regard, and such declaration shall be subject to the due process of law. 3. We inquired from the learned counsel whether Section 232(2) of the Elections Act 2017 has been challenged, and they said that they are not aware of a challenge thereto. However, the learned counsels are unanimous in stating that unless there is a clear pronouncement by this court on the matter, the returning officers in the forthcoming general elections may wonder whether to apply Section 232(2) of the Elections Act 2017 or the said judgment of this court, which may create needless confusion in the elections and shall not be conducive to democracy. There is also the likelihood of election tribunals and courts being inundated with cases arising out of the uncertainty. 4. The learned AAG points out that the Supreme Court Practice and Procedure Act 2013 requires that where constitutional interpretation is required, a bench of a minimum of 5 judges has to hear it. He further states that the interpretation of a federal law, the Constitution, and applicability of the decision of the Supreme Court is required, which will also impact elections to the provincial assemblies, and as such, requisite notices be issued. Therefore, notice under Order 27A of the Code of Civil Procedure 1908 be issued to the Attorney General for Pakistan and to all the Advocate Generals of the province. Notice be also issued to the Election Commission of Pakistan and public notice be published in a prominent English and Urdu newspaper having wide circulation, as the decision in these appeals may also affect those who are not parties hereto. 5. Concise statements attending to the said constitutional and legal questions without reference to facts and the particulars of individual cases may be filed. It is clarified that the pendency of these appeals and the questions raised herein shall not be used as a pretext to delay the forthcoming general elections scheduled to be held on 8 February 2024. These cases and any others involving the same question be fixed for a hearing in early January 2024 before a bench constituted by the committee under the Act.
Now please tell us, has Section 232 within bracket 2 of the Elections Act 2017 been challenged by anyone?
No, sir.
Is that correct?
It was challenged in the Lahore High Court. It was challenged in the Lahore High Court.
Where is the order?
I don't have the order, sir.
Let's go by orders. It was challenged, it was decided or not decided?
It was not decided, I think, sir. Because it was challenged. It's maybe
You challenge the act or somebody?
somebody, a lawyer from the Lahore Bar Council.
Who?
I exactly don't remember the name, but sir, it was challenged in the Lahore.
We can't go on conjecture, we have to go on facts.
हमने सर चैलेंज इसको इसलिए नहीं किया.
आप सिर्फ ये नहीं पूछ रहे हैं कि क्यों नहीं किया, हम सिर्फ ये पूछ रहे हैं किसी ने चैलेंज किया है तो बता दे. अच्छा चलें, एक बात तो ये हो गई. अच्छा, दूसरी बात, अब ये एडवोकेट जनरल्स ऑफ द प्रोविंसेस, do they support the attorney general or they have different contention?
Sir, from Shell, we support the attorney general, sir. And from Khyber Pakhtunkhwa, I also support the contentions of attorney general, please.
Who does not should just say so? Anybody? आप बलुस्तान और आप किधर से? You support the attorney general's contention or not? Huh?
Hello.
अच्छा, okay. Now, can we just, the judgment is dated when of the Supreme Court? Yearly 2018 Supreme Court. And so it is before this law was enacted.
31st January 2018, man.
13th April 2018.
Now let's start with the constitutional provision. Attorney General, if you can come back.
My lord, can I make a very small point?
Let's read the constitutional provisions, then we'll come to you.
Because, my lord, in my appeals, there is another issue also, another question of law which needs my lord's
We will come to
decision.
it. Let's just see what the provision was.
Sure.
And we will, don't worry, we will give you an opportunity. Now, can we read the relevant provisions?
My lord.
Article 62.
My lord, Article 62, Clause 1 and Subclause F. I'll begin by reading Clause 1.
The whole article.
G. A person shall not be qualified to be elected or chosen as a member of Majlis-e-Shura Parliament unless A. He is a citizen of Pakistan, B. He is, in the case of the National Assembly, not less than 25 years of age and is enrolled as a voter in any electoral roll in 1. Any part of Pakistan for election to a general seat or a seat reserved for non-Muslims, and 2. Any area in a province from which he seeks membership for election to a seat reserved for women. C. He is, in the case of the Senate, not less than 30 years of age and is enrolled as a voter in any area in a province or, as the case may be, the federal capital from where he seeks membership. D. He is of good character and is not commonly known as one who violates Islamic injunctions. E. He has adequate knowledge of Islamic teachings and practices obligatory duties prescribed by Islam as well as abstains from major sins. F. He is sagacious, righteous, non-profligate, honest, and ameen, there being no declaration to the contrary by a court of law. And G. He has not, after the establishment of Pakistan, worked against the integrity of the country or opposed the ideology of Pakistan. Clause 2. The disqualifications specified in paragraphs D and E shall not apply to a person who is a non-Muslim, but such a person shall have good moral reputation. This is Article 62.
63 pari.
G. Clause 1. A person shall be disqualified from being elected or chosen as and from being a member of the Majlis-e-Shura Parliament if A. He is of unsound mind and has been so declared by a competent court, or B. He is an undischarged insolvent, or C. He ceases to be a citizen of Pakistan or acquires the citizenship of a foreign state, or he holds an office of profit in the service of Pakistan other than an office declared by law not to disqualify its holder, or he is in the service of any statutory body or any body which is owned or controlled by the government or in which the government has a controlling share or interest, or being a citizen of Pakistan by virtue of Section 14B of the Pakistan Citizenship Act 1951, he is for the time being disqualified under any law in force in Azad Jammu and Kashmir from being elected as a member of the Legislative Assembly of Azad Jammu and Kashmir, or he has been convicted by a court of competent jurisdiction for propagating any opinion or acting in any manner prejudicial to the ideology of Pakistan or the sovereignty, integrity or security of Pakistan or the integrity or independence of the judiciary of Pakistan, or which defames or brings into ridicule the judiciary or the armed forces of Pakistan, unless a period of 5 years has elapsed since his release, or he has been, on conviction for any offence involving moral turpitude, sentenced to imprisonment for a term of not less than 2 years, unless a period of 5 years has elapsed since his release, or I. He has been dismissed from the service of Pakistan or service of a corporation or office set up or controlled by the federal government, provincial government, or a local government on the grounds of misconduct unless a period of 5 years has elapsed since his dismissal. Or he has been removed or compulsorily retired from the service of Pakistan or service of a corporation or office set up or controlled by the federal government, provincial government, or a local government on the grounds of misconduct unless a period of 3 years has elapsed since his removal or compulsory retirement. Or he has been in the service of Pakistan or of any statutory body or any body which is owned or controlled by the government or in which the government has a controlling share or interest unless a period of 2 years has elapsed since he ceased to be in such service. Or he, whether by himself or by any person or body of persons in trust for him or for his benefit or on his account or as a member of a Hindu undivided family, has any share or interest in a contract, not being a contract between a cooperative society and government, for the supply of goods to or for the execution of any contract or for the performance of any service undertaken by government. Provided that the disqualification under this paragraph shall not apply to a person, 1. Where the share or interest in the contract devolves on him by inheritance.
जरा बात ना करें माइक के सामने लाहौर से, आपकी आवाज यहाँ आ रही है, शुक्रिया जी।
Provided that the disqualification under this paragraph shall not apply to a person, 1. Where the share or interest in the contract devolves on him by inheritance or succession or as a legatee, executor or administrator until the expiration of 6 months after it has so devolved on him. 2. Where the contract has been entered into by or on behalf of a public company as defined in the Companies Ordinance 1984, of which he is a shareholder but a director holding an office of profit under the company. Or 3, where he is a member of a Hindu undivided family and the contract has been entered into by any other member of that family in the course of carrying on a separate business in which he has no share or interest. Or explanation. In this article, goods isko skip karke
not disqualification.
G.
So we can come to
M pe chalte. G. He holds any office of profit in the service of Pakistan other than the following offices, namely, again, an office which is not whole-time office remunerated either by salary or by fee. 2, the office of Lambardar, whether called by this or any other title. 3, the Qawmi Razakars. 4, any office the holder whereof by virtue of such office is liable to be called up for military training or military service under any law providing for the constitution or raising of a force. Or N, he has obtained a loan for an amount of 2 million rupees or more from any bank, financial institution, cooperative society or cooperative body in his own name or in the name of his spouse or any of his dependents, which remains unpaid for more than 1 year from the due date or has got such loan written off. Or O, he or his spouse or any of his dependents has defaulted in payment of government dues and utility expenses, including telephone, electricity, gas and water charges in excess of 10,000 rupees for over 6 months at the time of filing his nomination papers. Or P, he is for the time being disqualified from being elected or chosen as a member of the Majlis-e-Shura, Parliament or of a provincial assembly under any law for the time being in force. Explanation. For the purposes of this paragraph, law shall not include an ordinance promulgated under Article 89 or Article 128. 2. Then if any question arises whether a member of Majlis-e-Shura Parliament has become disqualified from being a member, the Speaker or as the case may be, the Chairman shall, unless he decides that no such question has arisen, refer the question to the Election Commission within 30 days. And if he fails to do so within the aforesaid period, it shall be deemed to have been referred to the Election Commission. 3. The Election Commission shall decide the question within 90 days from its receipt or deemed to have been received, and if it is of the opinion that the member has become disqualified, he shall cease to be a member and his seat shall become vacant. And then 63 is disqualification on grounds of defection. How do you
distinguish between 62 and 63?
My Lord, now, of course, 62 is qualification and 63 is disqualification, but both these conditions are applicable at the time of entry, at the entry point, which is to say that when a candidate files his nomination papers for Parliament or Provincial Assembly, must be eligible under both 62 and not ineligible under 63. And subsequently, if once a member gets elected, then again, he must...
No, it doesn't say elected. It says a person shall be disqualified from being elected.
From being elected.
So it's pre-election.
G 62, to, as I said,
63.
G63 also, it says from being elected, but
Some Article 3 says if he is a member.
if he is a member, then, and if there is anything, for example, now there could be few instances.
If you just, let's go to 62. Certain things are factual.
That's right, sir.
He is a citizen of Pakistan. Either he is or he is not.
And the
Two is age of 25 years. I mean, that's also fact. Either you are or you're not. There's no debate here.
And then being on the electoral rolls of a province, that is also
Factual.
Factual.
Now we go to C.
That's again with relation
Factual.
to sector.
Now comes the more difficult ones,
D to G.
which are, I imagine, not easy to ascertain. He's of good character.
And which...
Are you of good character, Attorney General? Don't answer that.
No, depends how you see me. That's what I had to say.
Please don't answer that. Okay. Not suggesting anything.
No,
but I'm just saying.
This actually says it
I'm
all.
just saying your supporters may say excellent character, and your detractors may say
It is
horrible
very
character.
subjective how you see, how you perceive what is a good character. What is good character? So it is.
And
Who will determine it? Who will determine it?
Yes. So that these are also all open-ended.
If you may see D, and it goes on to say who not commonly known as one who violates Islamic injunctions. So here it is, you may be in absolute violation of Islamic injunctions, but if it is not known, so okay, so it's very strange sort of wording. When we go to E, he has adequate knowledge of Islamic teachings. I don't know how many will pass muster in this courtroom, what level of Islamic teachings we are talking about. And practices obligatory duties prescribed by Islam, as well as abstains from major sins. Okay, now we all pray for forgiveness of our sins. So we are all sinners in that way. He is sagacious, righteous, non-profligate, honest, and ameen. There being no declaration to the contrary by a court of law. Now this is tied up with the court of law clause. The court of law, for instance, the cases before us were people not possessing a degree or producing a fake degree or not a recognized degree. So there is some sort of declaration that this was a stipulation. Now there is another thing inbuilt with that. The Constitution never provided for a degree. That's subordinate legislation. The Constitution did not want you to be a graduate. I think that was inserted in 2008. By Musharraf was then the president.
2002.
2002.
So, but it is not one of the prescribed conditionalities either of 62 or 63.
It was perhaps introduced under Clause P, subclause P of subclause 1 of 63. 63(1)P, which permits prescribing additional disqualifications through an act of parliament.
Read it again. P1P kya hai?
He is for the time being disqualified from being elected or chosen as a member of the Majlis-e-Shura, Parliament, or of a provincial assembly under any law for the time being in force.
Now, here the word time being has been used twice. It could have said he is disqualified for being elected. So time being.
Yes.
And it's been used, the word time being has been used twice in this thing. So it assumes it's not a permanent disqualification. I don't know.
That's what the first usage of for the time being actually indicates, what my Lord has just observed, that perhaps it is a time-bound disqualification which can be.
ख्वाब जो तारीख रकम करते हैं।
पैराग्राफ 35 है
जी 35 and
444 पेज पे
जी. So this is PLD 2018 Supreme Court 405.
ये चार जजमेंट जो पहले है ना,
very important.
उनका रेफरेंस है पहले इसके अंदर ना, चार जजमेंट हैं, उसके साथ फिर समीउल्लाह है
जी.
एक इम्तियाज अहमद का केस है, एक अब्दुल गफूर है, एक मोहम्मद खान है और एक अलादीनो भाइयो है.
Aladino Bhayo, first Aladino Bhayo, and then the review which came out later in 2020, and the court took a somewhat different view.
Mr. Attorney General, to nullify Samiullah Baloch, the amendment would have been in the Constitution.
My lord, that's why
I mean, if you're looking at the basis of the judgment,
Yeah.
the basis of the judgment emanates from the Constitution. So unless the Constitution were to be amended, Samiullah Baloch could not be undone.
So, because Samiullah Baloch is interpreting a constitutional provision, and Samiullah Baloch basically holds that the declaration which is referred to in 62(1)(f) has to remain in field till such time, the declaration in the field, the disqualification stands. Then what my lord has observed carries.
There is no time limit provided under Article 62.
So there are no time limits as far as my lord the Chief Justice had just gone through, took us through clauses A through G. Now as far as D, E, F are concerned, they are all without any timeline. Now the question before your lordship, and it was also argued in Samiullah Baloch. In fact, all the counsels before Samiullah Baloch.
If we consider that through Samiullah Baloch the Constitution has been amended, then the constitutional amendment is required, as per my understanding.
My lord,
It is interpretation.
Ji, my lord, with respect, Samiullah Baloch also read something into the Constitution which was not provided, and
Like? What did they read into the...
my lord, while comparing now, while examining 62(1)(f), the court held that so long as the declaration is in the field, this disqualification stands. While at the same time, when they were examining 63(1)(h), which is under 63 and relates to moral turpitude, which includes dishonesty, and there is a 5-year time limit, the court took a different view while examining both, and it said that, because there is a personal cost price that a person has prepared by going to prison, so therefore 5 years is good enough. But what the court did not, or with respect, overlook was that in both cases, the declarations are there. Now in 63(1)(h), there is a conviction which stands. It's only that
it's really a question of interpretation, because what's very interesting, speaking for myself, if you look at 63 G, H and I,
Yes.
I mean, most of the heinous crimes, especially against the integrity and sovereignty of the country, and that person can be allowed to contest election. Where there are punishments, he goes through punishments and comes out and contests election. What is a bit odd is that a civil declaration, which is just for some misdemeanor, like misconduct, which doesn't even carry a criminal punishment.
absolutely.
That carries an absolute bar for the rest of the life. That seems to be a bit odd, because if you commit murder, you commit treason, you commit whatever, you can come back and test election. But if you just forget to write something in the form, you would be out forever.
And
so how does one reconcile? So it's a matter of interpretation.
yes, so that is what my respectful submission would be, because in both, in G, H and also in I, there is an adverse finding against the person, a declaration by a court of law against that person. In those proceedings, those declarations of course subsist. He serves the time or whatever punishment provided by law, and then he can come back in after 5 years. Now here, while looking at 62(1)(f), where there is this, the standard of proof is lower compared to those criminal proceedings under 63(1)(h), which is beyond any shadow of doubt, and that declaration has still come out beyond any shadow of doubt. And here is preponderance of evidence or somewhere between the two, and here the person is out forever.
But before we go into that, could you just explain to us how can any court, a civil court, grant declaration which is in the negative? I mean, how can a court grant a declaration that you're not sagacious? That cannot happen. So how does that work? I mean, I've been always perplexed about this. We can't get a negative declaration from any court. Can a court say that you're not sagacious? Why would that happen? Because no civil proceedings could lead to a negative declaration. It's always positive. So I don't understand how a court will ever give such a declaration. So then most of the courts which have given this declaration are the constitutional courts. So you have
That's another
degree
question
case.
now.
And in those cases, is the declaration absolutely clear? I mean, does it say that you're not sagacious, or then we infer from the judgment that because you presented a fake degree, as a consequence, we understand that you are not a mean? I mean, let me just go to the language of 62(1)(f) to understand what do we mean by declaration.
Declaration, and also what is a court of law, because, and I say this, and my lord has just observed, in Ishaq Hakwani's case in 2015, a 7-member bench actually framed these 4 questions. They left them unanswered for some other case in future, and those questions were that what would be that court which is to give this sort of declaration? What would be the
happened
procedure?
then in that case?
They left it open, sir. These questions were not answered by a 7-member bench. So which court would it be? What procedure would it follow? What would be the standard of proof? And who will have the locus standi? Now, these are the questions which are very, very relevant for the purposes of for this declaration by a court of law. And then also whether the courts exercising, let's say, constitutional jurisdiction, who cannot record evidence, where witnesses cannot be cross-examined, a person against whom an allegation has been brought cannot really defend himself as he is able to in a trial, would the declaration coming from constitutional court suffice for 62(1)?
Mr. Attorney General, the question which has been there for a while now is, first of all, can there be a civil court granting a negative declaration, number one? And number two, the question is that in constitutional proceedings, where there is no evidence being taken, the court has arrived at a decision that a fake degree has been, for example, I don't know what the other cases are, fake degree has been presented by this person, does not necessarily mean that the court is moving further and saying that you are now non-sagacious or whatever. It's simply saying in this particular matter, a false degree was presented. But I don't know of any judgment where they've actually gone ahead and said, then as a consequence, you're a fraud. So I don't know. So is there a declaration actually coming out of the Constitutional Court also? And can they, without taking any evidence, give such a declaration about a person?
My respectful submission is, my lord, that a constitutional court, now mindful that this 7-member bench left these questions open, but then there are 2 judgments, one in PLD 2015 Supreme Court 265, which is Panama 1. Justice Ijaz Afzal Khan, speaking for majority, said that a court of law for the purposes of 62(1)(f) would be a court which can actually record evidence, which is a plenary court of original, revisional, appellate jurisdiction in civil and criminal proceedings.
But without recording evidence, declaration can be given?
Cannot be given. Yeah. And then the same...
But even a negative declaration cannot be given, even if you record evidence. Right, I don't understand this. So.
And then in Aladino Bhayo, the second Aladino Bhayo, the review Aladino Bhayo, they revisited the original judgment which was given in 2013, where under it was held that once a declaration under 62(1)(f) is given, it does not wither away, go away with the flux of time.
Declaration में तो यही है ना कि person may not file his own case for declaring him Amin.
Yeah.
Somebody has to challenge his character.
That's right.
Then in that case, the declaration will come whether he is Amin, sagacious, righteous or not.
Yeah.
So ये declaration होगा ना, खुद तो जाके नहीं मांग सकता declaration.
दूसरा negative as per
somebody will come challenging.
सिर्फ paternity पे हो सकता है शायद, एक exception है 42 में, there is no other exception.
Section 42 में तो legal character कोई deny करता है तो suit file होता है ना. If somebody is denying his legal character, then he can file the suit under section 42 of the Exclusive Act.
What right?
और अगर आप constitutional courts के cases भी ले लें ना, तो for example somebody has not, for example election tribunal says that the nomination form में फलां चीज नहीं है, तो मिस डिक्लेरेशन इन्होंने की है. चलिए बात तो हो गई, इन्होंने मिस डिक्लेरेशन की. अब इसका क्या मतलब, फिर हम खुद जोड़ते हैं, हम कहते हैं कि क्योंकि मिस डिक्लेरेशन की है इसलिए फिर आप अमीन नहीं है, इसलिए 62(1)(f) लग. But the court has not said it. The court is not declaring that you are non-sagacious or not Amin. But the court is simply saying you have filed, there's been a misdeclaration in the form. So उस पर जरा elaborate करें, how do we actually get, where is the declaration, actual declaration from the court of law?
उसमें कहीं पर वो correction के भी provision है, अब जो nomination papers हैं.
और ये सो मोटो डिक्लेरेशन है या कोई केस फाइल होने के बाद है ये डिक्लेरेशन?
Now, this is again very interesting because In some judgments in Sher Alam's case, for example, the court says that a writ for quo warranto can be filed, and that obviously comes in constitutional jurisdiction. And in fact, this court can take suo motu notice under 184(3) and gives
quo warranto देखे ना, वो तो Article 199 में it is totally different.
बिल्कुल.
The person has to show under what authority of law he is enjoying the office.
That's right, sir.
वो तो ऑफिस में जाने के बाद है, not prior to.
जी, ऑफिस में जाने के बाद होगा, but as far as that declaration is concerned, question is, can that declaration be given in those proceedings, or for that somebody has to go to civil court or some court which has the original jurisdiction to try and receive evidence, allow the person against whom an allegation has been brought to cross-examine.
एक चीज जरा देखिए, come back to Article 62. Read G.
He has not, after the establishment of Pakistan, worked against the integrity of the country or opposed the ideology of Pakistan.
Yes. Now, if we read 62(1)G on its own with the judgment of Samiullah case, the ban is lifetime ban.
But
If we read them together. Now read 63(1)G. It's the same language, ideology of Pakistan.
For propagating,
and here it prescribes a ban for 5 years.
Or the sovereignty, integrity, or security of Pakistan.
No, it's the same 62(1)G and 63(1)G are more or less similarly worded.
That's right.
It is working against integrity or opposed to the ideology of Pakistan.
That's right, sir.
Now, if we apply Samiullah Baloch to 62(1)G, it is lifetime ban. And if we apply 63(1)G, it is 5-year ban. Unless you say 62(1)G, Samiullah Baloch is not attracted to 62(1)G. That could be one argument. So
it's interesting what my lord has observed, because if a person is dishonest और उसके खिलाफ मुकदमा दर्ज हो जाए और उसको सजा हो जाए, तो फिर 2 साल काटने के बाद 5 साल बाद वापस आ जाएगा. मुकदमा ना हो और पता नहीं क्या हो और एक declaration आ जाए, तो then he's gone.
If he has been convicted and goes to jail, so his sins are expiated, right? And he's okay.
Yeah.
Now, if he is, for instance, acquitted or is not even prosecuted, then he is lifetime banned. So I find it difficult that a court of law which has convicted a person, meaning your guilt was established 100%, you are banned for only 5 years, and if your guilt has not been established, because every criminal case has 2 components, conviction and sentence.
That's right.
You can be convicted and you can be sent on parole, or you can be convicted till the rising of the court, or whatever it is, or maybe not. Say for good conduct, we don't convict you this time, we don't sentence you this time, we just convict you.
That's right.
So that will be a lifetime ban, and the person will say, can you please send me to jail so I can contest elections again after 5 years?
Yeah,
I would rather
the rising of the court, so I can just go back after 5 years.
So see, certain things are very clear. You are a citizen of Pakistan. I mean, I find okay that it's pretty clear. There may be some gray areas where you may be holding 2-3 nationalities or whatever the case is, or you may have given up or whatever. But generally, age is a determinative factor. It's clear. And then we come to D, E, F, and G, which are vague. And they're overlapping as well, because it says is of good character. Now, can any human being possibly say this on oath if he's truthful? If he's truthful.
So it appears that as far as D, E, and G is concerned, there's no third-party declaration. You know, who's actually saying that he doesn't have adequate knowledge of Islam? Who's saying that he's said anything against the integrity of the country? So there's no third party, right? So how does the disqualification work? On that election, and then it forgets about it, and then the next election he can contest? I mean, we found out that he doesn't have adequate knowledge of Islam. 20 years ago, and he missed the elections that time. Then he's now become a saint, perhaps.
Alim.
An alim. And then what happens?
Hafiz, alim.
So एक तो वो समझ नहीं आ रही, लेकिन फर्क सिर्फ ये है कि F में तो ये है कि एक declaration खड़ी हुई है third party की, तो जब तक वो खड़ी हुई है वो चलता रहेगा. That's what Samuel Baloch saying. Samuel Baloch actually turns on the declaration.
वो हुआ ये कि actually 18th Amendment में ये जो declaration by court of law लाने का purpose तो ये था कि वो returning officers जो है ना वो डिटरमिन ना करते रहे या इस किस्म का एलिगेशन कोई और रैंडमली ना आकर लगा दे, और ताकि ये जो डी, ई और जी के अंदर जो हो सकता है वो एफ में ना हो.
आपके मुताबिक
उल्टा हो गया.
How does D, E and G play out actually? I want to ask this question. आज से 10 साल पहले किसी ने इंटेग्रिटी ऑफ पाकिस्तान के बारे में कोई बात स्पीच कर दी, बस खत्म हो गई बात. अब वो इलेक्शन नहीं लड़ सकता.
ये देखिए कुछ लोग होते हैं तो
5 years कर दिए ना,
वो कहते हैं यस आई सीन द लाइट. अब इस्लाम में भी तौबा की गुंजाइश आखिर मिनट तक है. वो कह सकता है जी मुझे, जैसे माय लॉर्ड ने ऑब्जर्व किया कि मुझे इस्लाम के बारे में नहीं पता था, अब मैंने सारे अब लाइफ टाइम बैन उसको कर दिया कि वो फिर शायद हाफिज बन गया हो सकता है, आलिम बन गया हो सकता है, आप और बेहतर और हम सबसे बेहतर कुरान शरीफ समझने लगा हो, और वो लाइफ टाइम बैन में आ गया क्योंकि उसको 20 साल पहले या 10 साल पहले या 5 साल पहले इन चीजों के मुतालिक इल्म नहीं था.
समीउल्लाह बलूच जो है इट एक्ट्स एज अ गलिटीन. वो कहते हैं कि जब आखिरी अपील में जब आप आएंगे तो बस उसके डिसीजन से पहले तो अगर आप रिपेंटेंस कर लें तो हो सकता है, वरना वंस that happens then there is no repentance.
कहाँ छोड़ा?
नहीं छोड़ा. 184(3) में तो वैसे ही नहीं होता, बट अदरवाइज भी नहीं.
रिपेंटेंस कहाँ लिखा हुआ है?
साहब सुनने जरा, जी साहब
समीउल्लाह बलूच
देखें, इसमें असल बात यह है कि डिफरेंस हमने मालूम करना होगा 62 63A में. व्हाट इज द डिफरेंस बिटवीन द टू? एज फार एज आई एम कंसर्न, 62 is not giving power to decide against a person. देखिए इसमें तो सिंपल ये इट इज डिपेंडेंट अपॉन 63. 63 में जो कार्रवाई करेंगे वो दिखाएंगे, 62 में वो कहेंगे यू आर नॉट क्वालिफाइड. वेयर एज डिस्क्वालिफिकेशन इज इन 63. अगर कोई शख्स सपोज कोई काम करता है, कोई गलत काम करता है, तो अगर आप जी और एच को पढ़ लें, जी और एच वो डिटरमाइन करते हैं कि कोर्ट ऑफ लॉ से जब उसको कोई डिक्लेरेशन हो, ये उस डिक्लेरेशन की बात हो रही है. आई थिंक सो जी. इस पे बात करें कि ये 62(1)(f) कहाँ पे पावर देते हैं कि आप इतने टाइम के लिए डिस्क्वालीफाई हो, इतने टाइम के लिए. वो तो सिर्फ ये बताते हैं कोई शख्स पेपर सबमिट हो रहे हैं उससे पहले बता दिए कि ये फ्ला कोर्ट से इसको सजा हुई, लिहाजा पेपर खारिज. दैट्स ऑल. मैटर एंड्स. The authority dealing with this matter have no power to decide the disqualification period of that person. वो disqualification के period तो 63 ने बता दिया. ये सजा जुर्म करोगे तो इतनी सजा होगी, और उस जुर्म की सजा पूरी होने के 2 साल बाद जब आप निकलेंगे तो फिर आप क्वालिफाई होंगे. तो ये आप जो पहला सवाल जो आपसे किया कि डिफरेंस, आप डिफरेंस जब बताएंगे तो खुद ब खुद पता चलेगा व्हाट इज 62 एंड व्हाट इज 63.
So if 62(1)(f) is juxtaposed with 63(1)(h),
H and H both.
H moral turpitude.
H moral turpitude है because वो उसके साथ dishonesty etc. वो उसके साथ है moral turpitude being very broad, और वो एग्जामिन हुआ समीउल्लाह बलूच. उसको अगर आप सामने रखें तो the consequence then, if they are to be reconciled, then the consequence is only one, which is that the timeline which is provided for the declaration in 63(1)(h) must necessarily apply to the time to the declaration in 62(1)(f).
H में अगर conviction हो गई because it attracted an offence and so it led to conviction, then he can come back. But if it was lesser than even a case where it could constitute an offence and so he could not be taken in a criminal case, a simple declaration was given on the civil side, that goes on unlimited. अब यही समझ नहीं आती, because otherwise then we also have to stay away from the concept of reading into the constitution.
But now that you have started reading in, so I was just
that is also a question.
So you must stop from reading furthermore.
Reading in,
just another aspect if you can attend to. Can you read D,
my lord,
again?
He is of good character and is not commonly known as one who violates Islamic injunctions.
Now please read F.
He is sagacious, righteous, non-profligate, honest and ameen, there being no declaration to the contrary by a court of law.
Now, what does this mean? There being no declaration to the contrary by a court of law. In clause D, and in clause E, and in clause G, these words are not mentioned.
That's right.
So either you say clause D, E, and G are redundant, they're meaningless clauses, because the words, there being no declaration, either the same wording should have been followed. And I can't, at least I cannot understand the difference between good character and sagacious. I mean, good character is something different from sagacious. Is good character different from being righteous? Non-profligate. What does that even mean? What does non-profligate mean? What does it mean?
Who doesn't spend wastefully?
Israf.
Yeah.
So good character.
Yeah.
So if you are doing wuzu and wasting water, you become a profligate. Because there's a hadith of the Prophet.
That's right.
Do not waste water, and even if you're standing next to a flowing river. So then he's a profligate. So, and then we go honest. Good character, every good character person is an honest person, I would imagine. And Ameen. I mean, you know, these are words which a Muslim would never even dare utter in deference to the Holy Prophet, that only he is and none of us are. I mean, that is humility and abject humility. You will never say that. Otherwise, why would you seek forgiveness for whenever someone dies? Please forgive his sins. Do we ever say he's entitled to Jannat and Allah Ta'ala grant him Jannat? He never committed a sin. We don't even pray that for ourselves. No honest person will say any of these things, that he is sagacious, righteous, non-profligate. Even the greatest saints in Islam were scared when they were dying, that they were scared of death because they were apprehensive of what may they be meeting in the hereafter. So I don't know, is this generally a wish list kind of situation as opposed to because otherwise everybody can, if I was filing a nomination paper and if someone says he's not of good character, I would not even challenge it. I said, I'm sure I've done something wrong in my life. Maybe I've done it wrong yesterday, so I don't know. So if you're honest and you say, right, his person is right, I am not sagacious, righteous, non-profligate, honest. I do not switch off the lights when I go out of a room. I waste electricity. I waste human resources which the Almighty provides. So where does it end then? I can bring any case into disqualify someone, and I want to save someone, I can also do the same thing.
That's why.
Should such power vest in judges who are themselves humans?
That's why
They want a greater test for parliamentarians than they have for themselves. Does this language find mention in the oath of office of a judge? That I'm not profligate? Does it mention in the recommendations of a judge? All it says you have to be 45 years of age, practicing law for 10 years.
Could be
so we have a lower standard than parliamentarians. Why is this language then not reflected there as well? You know, let's accuse ourselves before we accuse anybody else what they are or what they are not. So either we have a much lesser test, we can't, at least I would be very scared to meet this test, terrified to meet this test. So either we don't have a similar test, so we have to read the Constitution as a living whole, and where the Constitution has brought down the acts, it clearly says 2 years, 5 years, 3 years, 2 years, or it's factual, you're not a citizen, fine, that's very clear. There is no punishment here, but you're out. So without a punishment, you're out. There's no punishment. So, but suppose a person is a citizen of Pakistan, not a Pakistani citizen, but becomes a citizen of Pakistan later. Would he stand disqualified for life? Suppose he filed a nomination paper and he had another nationality or whatever, and he got disqualified. Is it disqualification for life? And then subsequently he said, okay, I've surrendered my US nationality and now I want to contest. So I don't know, we have to read it in a way that is meaningful. And we must bear in mind the conditionalities that were imposed to exclude people from this. I mean, the degree situation. Thankfully, it wasn't there when the Qaid was around, because he would have been disqualified.
That's right.
No, he wasn't a graduate.
Amendment कब हुई? ये amendment
2002 की 8 की है
2002 में
55.
तो किसने की amendment?
This
My lord,
was
this
brought
is
to the
presidential order.
क्या वो प्रेसिडेंट खुद इन पे उतर सकता था, इन तमाम रिक्वायरमेंट पूरी कर सकता?
But ये जनरल मिलिट्री जनरल ज़ियाउल हक
नहीं
की
होते, बाद में डिग्रीज करते हैं, शुरू में नहीं होते।
नॉन इलेक्टेड मेंबर्स अगर अमेंडमेंट करेंगे तो यही होगा।
Mr. Attorney General, the question is that while we're looking at D, E, and G, which to my mind appears to be a guideline for the voters, the actual gatekeepers, and they might keep this in mind when they're voting because nobody can execute them and put anybody behind anything. So D, E, and G to sir guideline ho sakti hai voters ke liye, and that's never been agitated. The $1 million question is, how do we look at the line, no declaration to the contrary by a court of law? What do we do with this? I mean, this is
My
in the
lord,
Constitution.
if I may,
I think my lords have raised the questions. Can we read the law on declarations? What is the law on declarations? Section 42 of the
Section 42 of the Special Relief Act.
I would imagine, is that the only declaration that has been indicated here?
There's no other declaration. और तो कोई है ही नहीं.
कोई और law होता है declarations का? Specific Relief Act.
Only Special Relief Act, Section 42. Legal character के ऊपर जो है ना, वो that is the only law.
Declaratory suits are filed under 62(1)(f).
हो नहीं
Section 42.
Constitution में रहा. ये तो
इन्होंने कर दिया ना, बट अगर कोई चैलेंज करेगा तो वो तो 42 में ही करेगा. नेगेटिव डिक्लेरेशन.
Negative declaration concept है ना. Positive declaration is not negative declaration. We have held in paternity cases that you cannot do negative declarations.
paternity can
किया ना negative positive.
negative कर सकते हैं paternity.
नहीं negative positive हाँ. नेगेटिव नहीं हो सकता है क्या?
Person regularly character right of any property.
दे देना इनको स्पेसिफिक रिलीफ एक्ट सर. आप अटॉर्नी जनरल को दे देना.
कह सकता हूँ कि हम honest.
ये दे देना प्लीज.
ये मैं दावा फाइल कर सकता हूँ कि झूठा नहीं, मैं honest.
Yes, Ji.
But that's an entire.
Ji, sir. I have it before me. Mr. Jilani's iPad is very helpful. Discretion of court as to declaration of status or right. Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief. Bar to such declaration, provided that no court shall make any such declaration where the plaintiff, being able to seek further relief than a mere declaration of title, omits to do so.
By the court, to what is understood by court? A civil court?
Yes.
Under Section 9, or is it a constitutional court?
No, this is it's a civil court where evidence can be led, witnesses can be examined, where a burden of proof is discharged, and then there is an opportunity of rebuttal.
Suppose in a case where I've done so even, we observe hearing a civil petition for leave to appeal or an appeal that the appellant had dishonestly filed a suit. Suppose we hold that, and we've held so, and impose costs on him. Will that constitute a declaration of a court of law in terms of Article 62(1)(f)?
My respectful submission is no, sir.
Why?
Because you are not a court where that particular issue is actually conclusively determined through a trial.
So we could observe in other cases. We could say in a criminal case that I don't believe this witness is a liar. And that witness will then be struck by 62(1)(f) because it's a declaration of a court of law. In a judgment in a criminal case, he was not an accused there, but he was a witness. And the court says, I don't trust this witness. I found him to lie.
My My Lord,
So it's, then you can bring out every case. We may make an observation against a lawyer. He misled the court, for instance. Sometimes we do that.
My Lord, if I-
regretfully. And then if a lawyer contests election, the person will say, you have held that he misled the court. He is, of course, how can you allow him now to contest an election? He's banned for life.
My Lord, now,
जी साहब एक चीज और देख लीजिए, डिक्लेरेटरी जजमेंट्स का जो सुप्रीम कोर्ट के लिए प्रोवाइडेड है ना, वो आर्टिकल 184 सब आर्टिकल 1 में वो डिक्लेरेटरी जजमेंट्स हैं सूबे और वफाक के दरमियान जो झगड़े होते हैं ना, उसमें लिखा हुआ है कि सुप्रीम कोर्ट शैल प्रोनाउंस डिक्लेरेटरी जजमेंट। उसके अलावा के डिक्लेरेटरी जजमेंट 184 और 185 में लिखा हुआ है।
no, 184.3 is not mere declaration. I mean, 184.3, the court goes on to conduct.
शिजाज शौकत साहब यहाँ बैठे हैं जो सिविल कोर्ट के माहिर हैं, तो आप बताइए ना ये वाली डिक्लेरेशन कैसे होगी?
My Lord, दो चीजें ऐड कर
बयान पे
दूं।
बता दें।
आप सपोर्ट कर रहे हैं लॉ को या अपोज कर रहे हैं लॉ
But I'm supporting the law.
The law.
I'm against.
We want to hear from those who are opposing the law.
There's none.
So then-
apparently
नहीं,
there's
there
no
is
one
somebody who said yes.
here. Is that here about?
ये है ना,
जी,
I am opposing this.
So, yeah, I think in the course of proceedings,
let's hear.
the
I
challenge.
just want to understand how the opposition is.
That's right.
जी बताइए।
My lord,
ये आप अपोज कर रहे हैं तो पहले ये बताइए कि इसको चैलेंज किया है।
मतलब मैं लॉ को इस बारे में अपोज कर रहा हूँ।
नहीं, पहले बताइए कि अगर है तो हाई कोर्ट में चैलेंज किया वायरिस को इसकी आपने?
मैंने तो चैलेंज नहीं किया।
तो फिर अब क्या अपोज करेंगे आप?
गुजारिश ये मालूम, क्योंकि समीउल्लाह बलोच केस अगर मौजूद है जो कि कॉन्स्टिट्यूशन कर रहा है,
माइक अपने सामने।
तो इसीलिए तो आपसे पूछा ना, समीउल्लाह बलोच है, उसके बाद आप समझते हैं कि लॉ गलत अमेंड हुआ है, 232 गलत आ गया है, तो वेदर यू हैव चैलेंज द वायरिस इन द हाई कोर्ट और नॉट?
That can be challenged before this proceeding, my lord, because that question is just alive before the honorable and the same notice administration on that question. And in this proceeding, this honorable court has every authority to declare the law which has been passed in violating the provision of the constitution or whereby.
पर अभी उस्मान आपने कहा था कि are you supporting life disqualification or?
I'm
सर मैंने कहा था कि I am
नहीं, उस्मान ने क्या कहा था?
मैंने ये कहा है मालूम कि जब तक समीउल्लाह बलोच मौजूद है ये लॉ नहीं आ सकता, ये लॉ अल्ट्रा
पर मेन केस में आपकी क्या है कि डिस्क्वालिफिकेशन लाइफ को आप सपोर्ट करते हैं या नहीं?
मैं डिस्क्वालिफिकेशन को असिस्ट मैं इस पॉइंट पे करना चाहता हूं कि रीविजिट हो सकता है कानून, लेकिन वो इन कंडीशंस के साथ रीविजिट हो सकता है। वो मैं
एक देखें, वजाहत से बात कीजिए ना, गोलछोल बातें ना कीजिए ना। आप लाइव डिस्क्वालिफिकेशन के फेवर में या खिलाफ हैं? सीधी बात
मैं
करें।
लाइव डिस्क्वालिफिकेशन की फेवर में उस हद तक हूं कि अगर समीउल्लाह बलोच प्रवेल करता है,
आपसे सीधी
अगर
बात
नहीं
पूछ रहे
प्रवेल
हैं
करता
ना। हम ये क्या सवाल जवाब दे रहे हैं आप?
नहीं, either you support the principle or not.
लॉ को सपोर्ट मैं इसलिए नहीं कर सकता कि लॉ अगेंस्ट द जजमेंट ऑफ द सुप्रीम कोर्ट है।
अगर against the judgment है,
इंटरप्रिटेशन रीइंटरप्रेट हो सकती है प्रोविजन।
सुप्रीम कोर्ट का जजमेंट जब तक था उसके बाद पार्लियामेंट ने लॉ अमेंड किया। अगर आप ये कह रहे हैं इसका मतलब है कि सुप्रीम कोर्ट के जजमेंट के बाद पार्लियामेंट लॉ नहीं बना सकती।
लॉ बना सकती है स्टैट्यूटरी इंटरप्रिटेशन के बारे में, जहां स्टैट्यूट इंटरप्रेट हुआ हो।
चलिए लॉ का तो ठीक हो गया, but are you saying that the principle settled in Samiullah Baloch, you agree with it?
No, that I don't agree. I want to say that there is some conditions for the on the basis of state decisive principle कि कब वो जजमेंट जो है वो रिविजिट हो सकती है और क्या वो कंडीशन।
आप बार बार वही चीज रिपीट ना करें ना, अब आप सीधी बात हमसे कर नहीं रहे हैं। जजमेंट को छोड़ दीजिए 2 मिनट के लिए, लॉ को भी छोड़ दीजिए, हम सिर्फ आपकी राय मालूम करना चाह रहे हैं। आप लाइफ टाइम डिस्क्वालिफिकेशन को 62(1)(f सपोर्ट कर रहे हैं या नहीं कर रहे हैं? कुछ हाँ या ना तो कर रहे हैं।
मैं नहीं सपोर्ट कर रहा,
नहीं कर रहे हैं। अच्छा, हम सुनना चाहते हैं कि कौन सपोर्ट कर रहा है। एक सेकंड ठहर जाए, हम लोग सुनेंगे आपकी वक्त पे, कानूनी बात करेंगे तो करिए। आ जाइए, बताइए। एक सेकंड, लेट अस हियर मिस्टर समीउल्लाह बलोच, द पर्सन हिमसेल्फ।
जी,
सनाउल्लाह बलोच।
बिस्मिल्लाहिर्रहमानिर्रहीम। शुक्रिया मोअज़्ज़ज़ जज साहिबान।
ये आपका ये केस है?
जी सर, ये मेरा ही केस है।
ये तो लिखा है समीउल्लाह बलोच।
Sir, Samiullah Baloch is my brother, and Abdul Karim Nosharawani, I am the aggrieved person because I contested the election against
तो समीउल्लाह बलोच कहाँ है?
Abdul Karim Nosharawani. Sir, he is my brother because the case is mine. So
आप उनके अटर्नी हैं, आप कैसे आप पेश हुए थे क्या?
जी हाँ, मैं पेश हुआ सर, बिकॉज मैं एग्रीव्ड पार्टी हूँ। जो मैंने 2002 के बाद जब इलेक्शन हुए, मैं उसकी तफसीलात में बात
तफसील ना बता देना, आप बता दें किस ग्राउंड पे आप करना चाहते हैं।
मैं ग्राउंड पे सर, ग्राउंड ये है कि जो कॉन्स्टिट्यूशनल जो प्रिंसिपल्स हैं उसके तहत सुप्रीम जो जुडिशल सुप्रीमेसी है उसको मद्देनजर रखते हुए
ये ऐसी बातें ना करें अदालत में। जुडिशियल सुप्रीमेसी क्या चीज होती है?
मैं सर अगर आपकी इजाजत
नहीं ऐसी बातें ना करें हमसे। कॉन्स्टिट्यूशनल सुप्रीमेसी की बात सुनी थी हमने, अब आप जुडिशियल सुप्रीमेसी का मैंने कॉन्सेप्ट नहीं सुना है
सर। ये जो
नहीं देखिए कानूनी बात करें ना, ये ऐसी बातें ना करें
सर। ये जो आर्टिकल 62 और 63 है ये कॉन्स्टिट्यूशन में गुज़िश्ता 50 साल से और बिलखुसूस 18वीं तरमीम के बाद इसमें कुछ तरामीम हुई, लेकिन पर्टिकुलरली 62(1)(f) में तरामीम नहीं की गई। ये टोटल 5 सफ़ात पर मुश्तमिल कॉन्स्टिट्यूशन के अंदर बहुत क्लियरली एंट्री और एग्जिट पॉइंट्स दिए गए हैं हक के नुमाइंदगी के लिए, इख्तियारात के लिए। कहने का मकसद ये है कि सर जब ये 2013 के बाद से जब ये
अगर आप कह रहे हैं ना 50 साल से ये स्टैट्यूट बुक्स पे है तो पहले क्यों नहीं कभी कोई डिस्क्वालीफाई हुआ?
मैं इस पे आ रहा हूं सर। बात ये है कि सर ये जो है 2002 के बाद से ज़ेर बहस आया। ये 20 साल से सर सुप्रीम कोर्ट और बलूचिस्तान हाई कोर्ट और दीगर कोर्ट्स में ये तफसील के साथ ये ज़ेर बहस रहा है मौजूद, और इसमें 62 और 63 की बहुत ही क्लियरली केयरफुली मेटिकुलसली जो है सर इसकी तशरीह की गई है। मुख्तलिफ
मेटिकुलसली ऐसे तो ना बातें करें ना आप,
सर मैं
पॉइंट पे आ जाएं।
पॉइंट पे आता हूं। तो सर जब एक कॉन्स्टिट्यूशन के अंदर जब 63 की जब बात की जा रही है कि वहां 5 साल का तयन किया गया है, क्यों 62(1)(f) में नहीं किया गया? उसकी बुनियादी वजह यह है सर, जब मैं एज ए मेंबर पार्लियामेंट में जाता हूं, जब डिक्लेरेशन देता हूं, वो ओथ है। मैं ओथ में ये कहता हूं कि मैं शहरी हूं, मैंने BA पास किया है, मेरी उम्र 25 साल है। ये जब मेरे खिलाफ जिस शख्स ने कंटेस्ट किया था, जब मैंने उसको कंटेस्ट किया कोर्ट में, उसकी उम्र 24 साल थी। इलेक्शन में क्योंकि उसके पास वालिद के पास BA की क्वालिफिकेशन नहीं थी, तो उसका क्या हुआ कि उसमें 5-6 मिस रिप्रेजेंटेशंस की, उसमें फ्रॉडरी की, और जो डिग्री है
फैक्ट्स पे ना जाए ना। अब ये बताएं, जल्दी बता दें।
इस जगह ही सवाल है आपसे। आप ये कह रहे हैं ना कि ये जो डिक्लेरेशन जो हमें समझ नहीं आ रही सिचुएशन की, वो ये है कि मैक्सिमम झूठ बोला ना उसने, फॉर्म में झूठ बोल दिया, मिस डिक्लेरेशन कर, तो झूठ की सजा ये है कि सारी उम्र के लिए इलेक्शन प्रोसेस से आउट हो गया। ये लिखा हुआ है आइन। दूसरी तरफ हम पढ़ते हैं तो अगर कत्ल भी कर दिया, ट्रीजन भी कर दिया, तो फिर भी कुछ टाइम गुजरेगा तो वापस आ सकता है। ये बात रिकंसाइल नहीं हो रही है
सर। ये जो केस आपका समीउल्ला बलोच आपके सामने,
आप अपना बताएं।
मैं अपना बता रहा हूं सर।
मैं आपको आप केस को 1 मिनट रहने दें, आप अपना व्यू बताएं।
मेरा व्यू ये है सर,
बीइंग ए पॉलिटिशियन आप बताएं कि
63 के बाद जब किसी शख्स को सजा होता है तो वो एक इस्तेगमा है, उसके माथे पे एक दाग लग जाता है, वो 2 से 4 साल कैद का गुजारता है, पूरे माशरे में उसकी फैमिली सफर करती है, फाइनेंशियल सफर करता है, मॉरली सफर करता है, उसकी जारी सोसाइटी में उसकी अहमियत और हैसियत कम हो जाती है। उसके बाद जब वो निकलता है तो उसके बाद इजाजत है कि 5 साल के बाद वो जाए, अगर उसके पास गुंजाइश है वो आपके पास जाए। लेकिन इसमें सर जब आप एंट्री पॉइंट पे झूठ बोलते हैं, जब आप दाखिले के वक्त
नहीं, जैसे आपने कहा, देखिए एक पॉइंट लेते हैं, 24 साल का था, आपने कहा कि उस वक्त वो 25 साल का नहीं था। 24 साल का तो सिर्फ एक ही पॉइंट होता, उसके डिक्लेरेशन पे आपने उसको चैलेंज कर दिया, वो प्रूव हो गया कि 24 साल का है। आपकी राय में वो फॉर लाइफ डिस्क्वालीफाई हो जाएगा, फिर वो इलेक्शन कंटेस्ट नहीं कर सकता। Is it your point?
With your honorable permission, सर अब वजह क्या हुई? उस वक्त
पहले
ये मेरी वजह,
यही पॉइंट है आप
सर। मेरी ये पॉइंट उस वक्त इसलिए सुनी जब नहीं गई, वो शख्स दाखिल हो गया, उसने वो चेक बैरियर क्रॉस कर लिया, वो झूठ के बावजूद वो बलूचिस्तान में वजीर दाखिला बना, जो अभी से पहले केस।
फिर जातियात पे ना जाइए।
नहीं सर,
हम जातियात को छोड़ दीजिए, हम आईनी नुक्ते की बात कर रहे हैं। हो सकता है बहुत बुरा आदमी है, हम उसमें नहीं जाना चाहते, तो आप जातियात को छोड़ दीजिए, आइन की बात करें। आप पार्लियामेंटेरियन है ना, हम जातियात पे बहुत सकता है अच्छा आदमी बुरा आदमी, वो हमारे सामने बहस नहीं हमने करेंगे, क्योंकि हम एक जनरल प्रिंसिपल तयन करना चाह रहे हैं।
अब सनाउल्लाह बलोच साहब देखिए, मैं आपको बता रहा हूं, जो हमारे लिए कंपैरिजन में प्रॉब्लम आ रही है ना, एक तरफ 63A में आप जितना मर्जी क्राइम कर दें, आप कुछ अरसा सजा काटें, 5 साल गुजारें तो वापस आ जाए। हमें ये प्रॉब्लम हो रही है कि सिविल डिक्लेरेशन में सजा नहीं है, कोई सजा तो उसने नहीं काटी, सिवाय ये सजा उसने काटी कि वो वाला इलेक्शन मिस हो गया उसका। अगले इलेक्शन में तो वो आ सके ना। अब ये कहना कि अगले इलेक्शन में भी नहीं आएगा, कभी भी नहीं आएगा, ये हमें समझ नहीं आ रही कि सिविल उसने झूठ बोला, झूठ की सजा आपने दी कि तुम इस नॉमिनेशन पेपर रिजेक्ट हो गए तुम्हारे, तुमने इलेक्शन नहीं लड़ा, सजा मिल गई ना। जो क्रिमिनल साइड पे उसको वैसे सजा मिल रही, सिविल साइड पे ये सजा हो गई। अब आगे चले ना, अब वो क्या, उसने जो एक झूठ बोल दिया, मिस डिक्लेरेशन कर दी, अब वो सारी उम्र कैसे। दूसरी तरफ फिर तो हो रहा है, आइन में हर जगह लिमिटेशन है, टाइम की स्टोरी है हर जगह, तो फिर इस जगह भी तो कुछ होनी चाहिए ना। अजीब लगता
मैं इस हक में हूं कि 232 अभी जो जून
यार मैं इस हक की बात छोड़ देना, अगर देखें, अच्छा एक्चुअली आई एम स्पॉटिंग इज दैट मखदूम अली खान, कैन वी रिक्वेस्ट यू टू, since Mr. Makhdoom Ali Khan has written on the Constitution, I don't know if he's involved in any case before us. Are you in these matters? Huh?
Yes. My lord.
Which case are you in?
I have filed a CMA 6 of 2024.
For whom? In favor of disqualification or lifetime or not?
My lord, not in favor.
But you're not in, why, who have you filed it for?
For Mr. Jahangir Khan Tareen, my lord.
Okay. Now, one thing which nobody has attended to yet, at least one way of interpreting the Constitution is what the original Constitution said. And this Constitution has been, I don't know what's the correct word, changed or ravaged from time to time, what you want to use it. Can we read the original Constitution as it was enacted in 1973?
My lord.
And see what the Constitution then said.
My lord, I will read that provision to your lordship.
Would you like to do it, or shall we ask the Attorney General to do so?
As your lordship pleases, the history is...
No, we were thinking of appointing you as amicus, but you are representing a party, so anyways, let's...
as your lordship pleases.
62, do you have the original Constitution?
Yes, my lord, I have, and the history is traced in Samiullah Baloch.
No, we want to read the actual text.
Yes, my lord. The text is there.
85.
Yeah, we have it, my lord.
Qualifications for membership of parliament.
Can you come to one or the other mic?
My lord,
benefit of...
My lord, Article 62, there used to be only 3 qualifications. One, he is a citizen of Pakistan.
Read the whole article.
My lord, a person shall not be qualified to be elected or chosen as a member of parliament unless he is a citizen of Pakistan. B, he's in the case of the National Assembly not less than 25 years of age and is enrolled as a voter in any electoral roll for the election to that assembly. C, he's in the case of the Senate not less than 30 years of age and is enrolled as a voter in any area in a province, or as the case may be, the federal capital or the federally administered tribal areas from where he seeks membership. And D, he possesses such other qualifications as may be prescribed by Act of Parliament.
So these troublesome provisions were not there?
No, my lord.
When did they come into?
My lord, by Presidential Order number 14 of 1985, which is also called the Revival of the Constitution Order.
This is General Zia.
General Zia, when the martial law was coming to an end and partyless elections were soon to
Is it ironic that a person who violates the constitution of the country puts in these conditions? I find that a bit troublesome, isn't it?
Yes, he after D...
Was he of good character? If he violates the oath that he took to uphold and protect the Constitution, and he destroys the Constitution, it's very ironic for me that he inserts a good character, knowledge of Islamic teachings. I wonder which knowledge of Islamic teaching mandates judges to be sent home because they don't swear an oath of fealty to the martial law administrator. What is your view on that?
My lord, these are, with great respect, all these provisions which have been added by the RCO or the Presidential Order 14.
Was he non-profligate?
My lord, these are matters which I would say...
Yeah, we want your answer on this.
My lord, these are matters for divine judgment. These are matters for divine judgment.
You mean to say matter of treason is for divine judgment?
My lord, no. And treason is not an issue, but if we come to treason, then in
martial law is admitted?
Yes. If it comes to an act of treason, then in that particular case...
Do you think he committed treason or not?
My lord, in your lordship is talking of 1977.
You're talking about, yes.
Your lordship will then have to examine it.
You know, we are asking your opinion.
My lord, I would be bound by the judgment of this honorable
court. We are asking your opinion.
My opinion is different, but the judgment of this honorable...
Share your opinion with us.
The judgment of this honorable court in Begum Nusrat Bhutto's case takes a different view.
चले आप नहीं बताना चाहते रहने दें फिर.
My lord, my view.
चले बाकी पढ़ लेते 63.
63.
तो ये D तक था. There was no present D, present E, present F, and present G.
Yes, my lord. The D.
And 63 was also pretty succinct.
Yes, it was, my lord. 63 was also very limited.
कैसे उसमें हम पढ़ लेते हैं यही समझ
ये सारे
नहीं ला सकते ना
My lord, 63, a person shall be disqualified from being elected or chosen as and from being a member of parliament if A, he is of unsound mind and has been so declared by a competent court, or B, he is an undischarged insolvent, or C, he ceases to be a citizen of Pakistan or requires the citizenship of a foreign state, or D, he holds any office of profit in the service of Pakistan other than an office declared by law not to disqualify its holder, or E, if he is so disqualified by act of parliament.
So it was pretty straightforward and simple.
It was.
And RCO kind of molded the constitution.
Yes. RCO changed it and changed it in two respects. It brought in these qualifications and added a whole host of disqualifications as well.
By a person who was of sagacious, righteous, non-profligate, honest, and good character.
Yes.
Yes.
But the point is, 18th Amendment stamped on it. You see,
My lord, 8th Amendment stamped on it.
No, देखिए,
and then 18th Amendment.
Mr. Makhdoom Ali Khan, at least now I will speak for myself. I don't know. Wherever this is one way of interpreting the Constitution, and I've held it in a judgment or two, that wherever there is problem areas or difference of opinion or two interpretations possible, at least I've chosen the one interpretation which found mentioned in the original pristine constitution chosen by the directly elected representatives of the people and not martial law administrators. Why are you so scared of martial law administrators to utter these words, Mr. Makhdoom Ali Khan?
My lord, may I submit that this is also the jurisprudence of this court. In Al-Jihad case, Mr. Justice Ajmal Mia took the view that if there is a conflict or tension between two provisions of the Constitution, one which was enacted at a time when the Constitution was in abeyance and other at the time when the Constitution was in full force, it is the latter which will then prevail, and that view has been reiterated in Samiullah Baloch, though the principles drawn from it thereafter are different. So what your lordship is observing.
So where is it mentioned in Samiullah Baloch?
My lord, in the Samiullah Baloch case itself.
No, I just want to read that part.
Yes, my lord. Your lordship will see the constitutional principle is identified in the Samiullah Baloch case itself at page 435. Page 435.
At this point that you are saying?
Yes, my lord. This point is there on page 435. This is PLD 2018, Supreme Court 405.
Which paragraph are you reading?
Paragraph 22.
G.
If your lordship will see, there are a number of judgments cited, and then it says reference by the President, PLD's 1957, Supreme Court 219 at 235. As such, the Constitution must be interpreted as a whole because it is an organic document that is meant to apply to the changing circumstances of time and space. Consequently, each provision of Constitution or part thereof has purpose, meaning, and integral place that must be understood, acknowledged, and applied harmoniously. It is only when a conflict between two provisions of the Constitution is irreconcilable and one of such provisions was inserted when the Constitution was held in abeyance, then the provision which was made part of the Constitution during the period of its abeyance would yield.
But would it apply because after the 18th Amendment having stamping it, so it's not really, that was a democratic dispensation at that time.
My lord, it was, but your lordships prior to this also in Al-Jihad's case took the view that in spite of the fact that whatever General Zia had done had been validated to a large extent by the 8th Amendment to the Constitution, this honorable court took the view that was in particular, my lord, in relation to a provision where a judge of the High Court declined to go to the Federal Shariat Court and was as a result sent home. Their lordships took the view, particularly Mr. Justice Ajmal Mia, that this provision was inserted at a time when the country was going through a period of constitutional abeyance. No doubt it was validated by the 8th Amendment, but when we examine it and juxtapose it with other provisions relating to judiciary, this having been added at the time cannot be allowed to hold sway, and that is why their lordships held that a judge of the High Court cannot be sent to the Federal Shariat Court against his will, and if he refuses, will not cease to hold the office of a judge of the High Court. So, in spite of that, this has been the jurisprudence of this Honorable Court, that in spite of the validation.
Mr. Makhdoom Ali Khan, but would you put validation at par with an original enactment which has been thought about, carefully considered by every member of parliament? A validation was also a bitter pill for the parliamentarians to swallow. If you don't validate, I continue. So it may be that, okay, we are getting something, is better than nothing. Let's at least get on with it. But we are now faced with a problem. So simple validation, when the original constitution said something else, if there are two possible ways to interpret something, and more so when what has been added is very ambiguous. I don't know why these vague words were introduced. You could have simply said A, B, C, D, like every other thing is factual. Either it's a yes or it's a no. Are you all of good character? Please don't answer this question. But which person would say this? I mean, it would be a very audacious person who would say, I'm honest, Ameen, and everything. And then probably he will be making other claims which will be totally not permissible. So simple validation is a bitter pill which has been swallowed from time to time to get democracy back on the rails. Would you not agree with that, since we consider you a constitutional expert, to consider validation at par with a constitutional provision, or it has to be read in the context of, because this judgment also says in space and time. The space then was a dictatorship. Either you continue another 10 years of a dictator or get some sort of a diluted form of democracy, get us back on the rails, whichever is better. So probably the parliamentarians, we should not always condemn the parliamentarians. We should see the difficult circumstances that they work under. I mean, we should respect them. And what would you have done? Let's put yourself in the position of parliament, make yourself a parliamentarian then, that you would, validate something which you may not be very happy with, but at least get the business back on track. How would you personally attend to it?
My lord, my respectful submission is that though the earlier two judgments which I have just identified by this Honorable Court do not put it in the terms that your lordship has, but that was probably at the back of their mind when they said that an amendment made during the period of constitutional abeyance, if it is in conflict with or cannot be reconciled with the provision originally enacted in the Constitution, then the latter will prevail. So obviously this Honorable Court has not treated the validation at the same level as the original Constitution, recognizing all the difficulties which your lordship have articulated, but not articulating them in this particular manner. Otherwise, my lord, if any amendment made to the Constitution, eventually when made, stands on the same plane as any other constitutional provision, but your lordships have held that we will distinguish between constitutional provisions made during a period of constitutional abeyance.
What's your main argument? Is this your mainstay of your argument?
My lord, my main argument in this particular case would be that insofar as when your lordship examines Article 62 and 63, because some of these amendments, as your lordship has just now noticed, came in at the same time, there is a relationship between the two. And with great respect to this extent that Samiullah Baloch says that 62 and 63 have to be looked at through different lenses, it is, with great respect, incorrectly decided. Because when your Lordship looks at 62 and 63, and the amendments came about at the same time, 62F, which your Lordship is looking in particular, which says he's sagacious, righteous, non-profligate, honest, and Amin, there being no declaration to the contrary by a court of law, and your Lordship examines it with 63(1)H, he has been on conviction for any offence involving moral turpitude, sentenced to imprisonment for a term of not less than 2 years, unless a period of 5 years has elapsed since his release. They are to be read together.
I mean, that is dependent upon 62 is dependent upon 63.
63, and I would go to the extent of saying that when your Lordship looks at G, for instance, he has not, after the establishment of Pakistan, worked against the integrity of the country or opposed the ideology of Pakistan. It has to be related to H, which says he has been on conviction for any offence involving moral.
So what does that mean? I mean, where does that leave these provisions 62?
My Lord,
what's the effect?
My submission would be that unless there is a conviction, and that would be the declaration I would be seeing, not at...
So what are these clauses? They go?
My Lord, if there is no conviction, then in the case of
D, F, E, and G, for example.
My Lord, D and E and F probably all will have to be related to H. 63(1)H.
F actually talks about a declaration. D, E, and G don't. They could be. One could argue that because there is no third-party declaration, we can go into conviction area. But where do we take the declaration part?
My Lord, declaration. Now, if your Lordship looks at it in terms of section. One thing which immediately comes to mind is section 42 of the Specific Relief Act, which talks about declaration of a legal character. Now, this cannot be that kind of a declaration because, as your Lordships have repeatedly observed, a negative declaration is impossible to obtain. Then your Lordship,
sometimes permissible, negative declaration is permissible sometimes in some events that can be granted by the court.
There has been some revisitation or some revisitation of Alvi Sons, but otherwise that remains good law. Then if your Lordship looks at 199, that also is talking of declarations being made by this Honorable Court, but that's in a completely different context.
That is only.
So then what do you make out of this declaration for a court of law?
My Lord, I would say that the term is not used specifically in the section 42 sense of the term.
Maybe it's a constitutional declaration.
It's a constitutional declaration, and that the declaration which the Constitution is envisaging is there has been a conviction already under 63(1)H. And then there is this gateway. He cannot file his papers before the returning officer because at that time the returning officer may refuse to accept them. But the anomaly which arises when your Lordship looks at 63(1)H in particular, and G and H both, actually, when your Lordship looks at it, for instance at H, he has been on conviction for any offence involving moral turpitude, sentenced to imprisonment for a term of not less than 2 years, unless a period of 5 years has elapsed since his release. So even a conviction which is followed by a sentence of 1 year 11 months does not lead to disqualification even of 1 day.
Enough. So that's understood.
So therefore the connection which Samiullah Baloch makes between a person being an ex-convict suffering all his life, the stigma that he's a convict, is really not what 63(1)H is all about. 63(1)H is all about sentencing. If the person has been convicted and sentenced till the rising of the court, he's not disqualified at all.
No, but there is a difference, you see, the opening paragraph of section 62 and 63. They need to be read and harmonized. A person shall not be qualified to be elected or chosen. I mean, if you will read 63, a person shall be disqualified from being elected or chosen. So वो जो उसमें चीजें लिखी हैं वो आफ्टर कन्विक्शन है कि अगर कोई कन्विक्ट हो गया है उसकी सजा खत्म हो गई है तो इस इतने पीरियड के बाद वो इलेक्शन लड़ सकता है टू बी इलेक्टेड and from being elected. This is the
correct. But
yes.
If your lordship may graciously be pleased to look at clause 2 of 62, these words are used very loosely. The disqualification specified in paragraph D and E doesn't talk about qualifications. Article 62.
But both are different situations.
No, my lord, Article 62, clause 2, is talking of disqualifications under 62. It's not talking of qualifications. So this is very loose language which has been used.
Practically interchangeable.
Interchangeable language. Because
one question which I have. DE does not have the wording there being no declaration to the contrary by a court of law.
My lord, yes.
When does D, E and G kick in?
How can they ever kick in actually in any court of law? They cannot kick in.
Or they're meaningless words.
My lord,
it's just guidelines for
they are exhortatory perhaps for the guidance of the electorate that watch out for candidates.
So first of all, you are saying that they are of no, there are no consequences which follow with D, E and F. D, E and G.
They will, my lord, D, E.
But ideally, the same wording should have been used, there being no declaration to the contrary by a court of law in D, in E and in G.
My lord, these
wordings are only found mentioned in F.
My lord, these were added in F under the 18th amendment. These words were originally not there. And the reason for adding it appears to be, as the Attorney General identified, that under F, returning officers had started disqualifying people by saying, "Aap chautha kalma zara suna dijiye." आप चौथा कलमा जरा सुना दीजिए इस तरह की चीजें
they can still do that in E.
they can they very much
that's
can.
The problem, you see, what we don't understand is D, E, G are there, and what do we, they're not executable as such. How could we? So I mean, I myself read them as for the gatekeepers, as the voters, and maybe they keep that in mind and not vote because it's a subjective decision.
My lord, yes.
But cannot be enforced in a court of law.
My lord, that is what in the case of Ishaq Khan Khakwani, one of the learned judges, as my lord Mr. Justice Faiz Isa identified in Sheikh Rashid's case, took the view that no disqualification can really take place over here. These are very open-ended words. And your lordship points it out in your dissenting opinion in Sheikh Rashid's case, where your lordship identifies the 7 questions which are to be dealt with by the court, because that's...
But Mr. Makhdoom, the problem is that I'm facing is you can't attribute redundancy to the Constitution.
My lord, yes.
Or to any law for that matter. And then secondly, you can't read into the Constitution. So
My
the
lord.
time frame, suppose if one were to say that this F applies for that election, that particular election which the nomination papers are rejected, and it ends. Now that's not written. So how, I mean, that's the worry that I have. How do we read in a time frame into it? Either we read them with 63 and create a larger timeline concept. How does it work? Or go on the validation point.
And if I may just add what my learned brother has just said, what I've understood from your submission is what you are saying, Samiullah Baloch does not accord with the Constitution.
That's the submission.
That's your argument. Can we not say that Samiullah Baloch for its time was good, valid judgment? However, since the lacuna has now been provided by Parliament, and they've given a 5-year time limit, both can be reconciled. That was good then, and now 5 years is. If your 5 years have expired, would you agree with that, or you would not agree with that?
No, I would absolutely agree with that, my lord. My submission is that Samiullah Baloch was enacted, was decided at a time when we didn't have this newly amended law. At that time, the law did not, and there was no timeline set. The Samiullah Baloch case was decided in a particular manner. The legislature has now filled that gap. In Samiullah Baloch, it was observed that there is a declaration until such time that the declaration stands. then the person would remain disqualified or will not be qualified. Now the legislation says that the period of such a declaration will not go beyond 5 years.
Okay, now I will ask you the supplementary question, and I knew you would come here. Thank you. Now can I put it to you that section 232(2) is unconstitutional? Can I put this to you or not?
My Lord, that is a very valid question. Of course, Your Lordship can put any question.
Yes.
My Lord, because one view can be, which is probably not probably, in my opinion, definitely the correct view, that where this honorable court has interpreted a provision of the Constitution and made a declaration about a provision of the Constitution, then on the doctrine of legislative repeal, that constitutional interpretation can only be undone by an amendment to the Constitution.
And that brings us to the question that how could the Constitution be controlled by a sub-constitutional legislation? The Constitution is talking about a declaration, gives no time frame. Could we, through an act of Parliament, start adding things to the Constitution? We can't do that.
My Lord, I would say that the declaration made by the Parliament is in consonance with Article 63(1)(h) of the Constitution, which provides a time frame for the kind of offences which will fall under F.
Because that involves conviction, that's a criminal case. But if you look at 63P, 1P or whatever it is, the P, the last one.
Yes, madam.
The Constitution itself allows that through an act of Parliament you can regulate this provision. And wherever it's so required, it's given.
So, just taking it a little more, suppose, let's imagine Samula Baloch was not decided. And we are deciding it today.
My Lord.
Just for the sake of, to take the argument a bit forward, and let's assume everyone agrees with me, and we say since 62(1)(f) does not provide a time limitation for disqualification, therefore let us be guided by other provisions of the Constitution, including 63(1)(h) and (g), where it provides for treason, 5-year disqualification. So let us let this disqualification be for 5 years. Is it sound reasoning or not?
My Lord, it is, because Your Lordship is then virtually interpreting the two provisions together. When Your Lordship interprets...
So at the end of the day, it depends on what is in my mind. Are you understanding?
Yes, ma'am.
Is the Constitution so malleable that I can do whatever I want to with it?
My Lord, if 63(1)(h) was not there, let us assume there was only 62(1)(f), and if the 18th Amendment had not added the words which have been added, which is declaration to the contrary by a court of law, then 62(1)(f) would have been a provision which really provided no timeline. And if a person was declared not to be qualified under 62(1)(f), then the question would be for how long? My Lord, the question can be for that term that he has been elected, or he can be re-elected immediately. My Lord, for instance, the only other constitution that I have been come across, which is a provision similar to that of Pakistan, where you cannot be elected to the parliament if you are the citizen or have acquired the citizenship of another country, is that of Australia. And the Australian High Court has dealt with this issue. No other constitution that I am aware of deals with.
American Constitution, you have to be an American...
You have to be an American citizen, but it does not say like our, my Lord, 63(1)(c) says, or acquires the citizenship of a foreign state. So a dual citizenship over here disqualifies. In the Australian Constitution also, a dual citizenship disqualified. But the lordships over there have taken the view that if the person then steps down, abandons that citizenship, he can come back in tomorrow again. And there they have also taken the view that if he has applied for his citizenship to be renounced, then the constitution of our country will not be contingent on the delay or speed of the legal processes in another country. He has done the best he can, and therefore they have said he can continue to be in office.
Why were you disqualified?
My lord?
Why have you been disqualified?
From
the petitioner.
The petitioner.
Yes.
Petitioner was disqualified.
Your client.
My lord, my client. Yes, I was coming to that. My lord, he has been disqualified on the ground that he had created a trust for the property called Hyde House, and his defense was that Hyde House was a trust. The
misdeclaration in the nomination form, is that the allegation?
Yes, but his case was that there was no misdeclaration.
No, that's a different thing. I just want to know what was the reason.
So in all these cases, if you look at all these cases that where 62(1)(f) was invoked, the misdemeanor is misdeclaration, or maybe they have not given misdeclaration. Generically would be it, and misdeclaration in the worst form taken could be brought into H. Worst form, moral I mean, कहीं हो सकता है innocently भी हो, लेकिन चलें worst form में ले लें, it is moral turpitude, and that provides for 2 years plus 5 years, so that's 7 years. So even if suppose a person did not get convicted because there was no case filed, worst to worst, if the case was there, he would be out in 7 years. So 7 years period could be easily read into the F clause, because that's the only natural corollary. I mean, it doesn't make sense otherwise.
Yes, my lord. And again,
would there be any incident coming out of F which will go out of H?
My lord,
मतलब आपने नई केस बनाया, सपोज मिसडिक्लेरेशन हुई, उसके खिलाफ किसी ने कोई क्रिमिनल केस ही नहीं किया, अगर हो जाता तो वो 2 साल वो होता और फिर उसके बाद 5 साल होता, यही है ना? Is there any situation in F which would go outside H?
My lord, not that I can think of. No.
Do you think the words in F, it says, it doesn't end by a country, by a court, it says court of law.
My lord, yes.
Is a court of law different from a constitutional court? Because it could have stopped at the word court. So I just want to know, does it, the of law add anything or doesn't add anything?
My lord, of law adds in the sense that probably the returning officer will not have this power.
The returning officer is not a court. I'm just thinking in terms of Section 9 courts under the CPC. Are these court of law Section 9 courts or court of law, because it should have said, it could have ended by saying by any court.
My lord, over here,
are we distinguishing between the constitutional court and a civil court of competent jurisdiction, or we are not? It's meaningless, irrelevant.
This honorable court and your lordship yourself have held that over here the word court of law means a court of plenary jurisdiction. In Panama 1, which was not subsequently followed in Panama 3, this honorable court.
What do you mean by Panama 1 and
Panama 1, my lord, was the first case which was decided 3-2, and Mr. Justice Ijaz Afzal Khan, writing for the majority, said that court over here means a court of plenary jurisdiction.
Meaning Section 9 court.
Section 9 court, a court which will take evidence, which will examine the issues where a trial takes place.
Or it could be civil or criminal.
He doesn't make that distinction, and I would submit that if your lordship have to,
then how did that view change
without mentioning what they have done in Panama 2 and Panama 3?
Is it referred to Panama 1 and Panama 2 and 3, this aspect?
No, my lord. Your lordship notices that in your lordship's judgment in Sheikh Rashid's case.
Actually, that was not a judgment, it raised a number of questions.
Yes, it raised a number of questions.
Yes.
But your lordship will see that even after Samiullah Baloch, different tests have been applied. The author judge of Samiullah Baloch was also the Chief Justice of Pakistan in Faisal Wabda's case, and has taken a different view without any reference to Samiullah Baloch.
Where is that view?
My lord, that is reported. My lord, that is Muhammad Faisal Wabda versus Election Commission of Pakistan and others.
PLD kya?
My lord, this is 2023 SCMR 370. My lord, 370. My lord, I have put these cases together in a bundle for ease of reference of your lordship. And this
देखिए ये और भी
सर
मैंने और पैसे जाया करवाए आपके
सर, ये आपके जो 62(1)(f) पे जजमेंट्स हैं,
ये पहले बताएं ये वाला केस.
Yes sir, it is the last tab. It is tab 20.
You're a member of this.
Yes.
Well, my lord is one of the members.
Yes. His lordship is one of the members.
You said it as if it was something wrong.
Can you read the relevant portion?
My lord, yes, paragraph 4, it's a 2-page judgment really. Paragraph 4, page 373. The petitioner states before the court that he regrets his claim of renunciation of the US nationality at the time of filing his nomination papers for the election of NA 249 Karachi on 7/6/2018. He further states he had then initiated a process for such renunciation, but the certificate of loss of nationality of the US was issued to him on 25th June 2018. He admitted that he was disqualified from contesting the election under Article 61(3)(1)(c) of the Constitution on the date when he had filed his nomination papers for the election of NA 249 Karachi, and that his affidavit filed in with the nomination paper thus contained an erroneous statement which he regrets. In order to demonstrate his good faith in remorse for his mistake, he undertakes that he will resign from the office of the member of the Senate to which he was elected. In view of the said statement and undertaking of the petitioner, we are of the opinion that we need not proceed further in the matter in the peculiar facts and circumstances of the case. And if your lordship will see the last sentence, which is the last 3 lines, it is clarified that the petitioner shall not be considered disqualified in any subsequent election on the basis of the instant.
The repentance is that period, that particular election.
Yes, and so, but this is after he enjoyed the full tenure of the Senate.
Yes, yes, and then he resigned. He resigned.
But एक चीज देखिए, समूला बलोच में paragraph 6 में the concept of repentance is mentioned.
Yes, my lord.
But I don't find a finding on it then.
No, there is
argument of counsel finds mention on repentance.
My lord, yes.
But then it is, though the judgment talks about Islamic injunctions, this concept is not discussed unless I've missed it.
No, it is not discussed, my lord. That judgment is also on tab 7 of this very bundle.
So are you repentant?
So, Mr. Makhdoom, we could look at it like this, you see.
Are you repentant or you claim you've done no wrong?
My lord,
at the moment you can only be repentant because your case is over.
My case is over, yes.
I presume you are repentant.
So one reconciliation.
Reluctantly repentant.
My lord, his case was that I made no misdeclaration.
No, वो तो बात खत्म हो गई.
My children had declared it.
वो तो हम review करने में बैठ जाएंगे. वो तो फिर हम review करने बैठ जाएंगे judgment.
So one reconciliation of 62(1)(f) with H could be that if there is a misdemeanor of misdeclaration and no case, criminal case is made out, then he just misses out on the election and the matter comes to an end.
Yes.
But if you want to take it further and you file a case against him which is criminal, then H kicks in and you go through a conviction and 5 years. So there's a 7-year period there and there's an election period here.
Yes,
because why didn't you not book him in any criminal case? Because you could do that. For any misdemeanor, you could have done that. If you don't let him go and you don't take criminal proceedings, then there has to be some mechanism, because if you take criminal proceedings, the mechanism is 7 years. But if you do not take criminal proceedings, then there must be some way out also. Because it's short of that, because nobody bothered to take the person on for that misdemeanor. So, I mean, that's
Mr. Makhdoom Ali Khan, but I think, can we go back to Faisal Wavda's case, please?
My lord, yes.
You said Samula is not mentioned. Samula is mentioned there.
Is mentioned.
ये जरा उससे पहला वाला पढ़ने, therefore.
बिल्कुल उस paragraph में mentioned है. It's mentioned, but not followed because Islamabad.
No, just पढ़ दें जरा सा. Therefore, it was concluded.
My lord, उससे अगर जरा ऊपर आप देख लें, the Islamabad High Court found that the petitioner was disqualified pursuant to the case reported as Speaker National Assembly of Pakistan versus Habib Akram for submitting a false affidavit, hence no declaration was required. Therefore, it was concluded that the consequences given in case reported as Samiullah Baloch and others versus Abdul Karim Noshirwani would follow by finding that a formal declaration by a court of law was not required to disqualify the petitioner under Article 62(1)(f) of the Constitution. The impugned judgment has in its para 11, 12 and 13 therefore misconstrued both Habib Akram and the Samiullah Baloch case. So they say it's been misconstrued, and resultantly the impugned judgment is legally not sustainable.
How do you reconcile the two? This judgment and Samiullah Baloch?
My lord, if Samiullah Baloch was...
No, how do you reconcile the same two judgments by the learned same judge?
My lord, my submission is that if Samiullah Baloch was strictly followed, there was no way out but to disqualify Mr. Faisal Wabda in Islamabad High Court. For life, because Islamabad High Court had correctly decided the case.
He will be disqualified because of his corrupt practices.
Who, my lord?
The person who gives false statement.
Yes, my lord.
Corrupt practice defined in section 167 of the election laws.
My lord, yes.
But for that declaration, there must be criminal proceedings as provided in section 174.
Yes,
penalty for corruption or corrupt practices. उसको सजा होनी चाहिए कोर्ट से.
जी.
Court means criminal court.
Your lordship is absolutely
When there is no
right.
declaration from the court, can person be still called as a corrupt practice?
My lord, that is my submission, that 62(1)(f, the declaration which they're thinking about is the declaration under now the Election Act 2017, previously the Representation of People Act 1976, and the words used over there were
false statement and false declaration.
Yes.
So punishment for punishment, the court, criminal court.
Yes.
There must be a fair trial. Article 10A. Thereafter, if the court declares that the person has committed an act of corrupt practices,
that is why your lordship will have to read 62(1)(f).
Once that declaration is made, then under 62, if somebody shows at the time of submission of papers that this person is disqualified, is not qualified to be elected, his papers can be rejected. Whether in 62 period of disqualification can be made or not.
My lord, my humble submission is...
Are you also in this case, Mr. Mohammed? Yes. Are you also in this case?
My lord, I'm assisting Mr. Maktoum Ali Khan in the same matter, my lord.
Okay, sorry.
I was counseling.
We wanted to hear the other version as well. Because all of you seem to be on the same side in a way. So we wanted better articulation of the contrary viewpoint. Who would canvass that viewpoint? Anyone in the court who will canvass the contrary viewpoint with some level of seriousness.
Except Sana Baloch, everyone.
Sir, if you allow me just...
No, anyone in this courtroom who wants to canvass the contrary viewpoint with the level of seriousness, we would like to hear. Because you're an Attorney General and most of them are just saying what you are on the same side.
My lord, I would like to submit.
कौन बोल रहा है?
From Lahore. Khurram Raza from Lahore, my lord.
Okay, then you please make yourself attend here. We don't want to hear important cases on video link. If you are serious about this case, come to Islamabad.
My lord, I will.
Someone who has the opposite viewpoint, senior counsel, Mr. Maktoum Ali Khan.
My lord,
the contrary viewpoint.
I think all the respondents.
Where is Mr. Shoaib Shaheen? He was here in the morning. Would he be canvassing the contrary viewpoint? Shoaib Shaheen साहब चले गए? अच्छा.
Mr. Babar Awan supported the lifetime ban in the Samila Baloch case, so he might be a
कौन बोल रहा है? आप किस point? Mr. Qayyum,
Mr. Babar Awan.
No, what about yourself? What about yourself? What about yourself? Which view are you supporting? Lifetime ban?
My lord, I am supporting the law. I am against lifetime ban.
अच्छा, आपके साथ जो खड़े हैं वो क्या कहते हैं?
वो अपोज कर रहे हैं।
आप आइए जरा इस्लामाबाद, जरा अपनी हमें दीदार कराइए. We don't want to miss any valuable word uttered by you. So please be here. We will now be adjourning this case, and we would like to maybe we appoint some person from the other side, if we can say, आप
बल्कि अगर आपको कोई और सपोर्ट कर रहा है उसको भी साथ लेके आए लाहौर से।
My lord, there is a
नंबर में कौन है केस में? जो सुबह का केस था, ये सैयद असगर हुसैन सब्जवारी, ये केस है काशिफ महमूद का। आप किस पॉइंट ऑफ व्यू को सपोर्ट कर रहे हैं? क्योंकि ये आपने सुबह का केस, ये यही इशू है आपके केस में, आप लाइफ टाइम बैन सपोर्ट कर रहे हैं या नहीं?
नहीं जी, मैं तो ये कहता हूँ कि
नहीं, सिंपल बता दें, लाइफ टाइम बैन और 5 year बैन और नो बैन? लाइफ टाइम बैन। सो माशाल्लाह आप खुद हैं, तो आप आते ना सामने, हम आप बार बार पूछ रहे हैं। नहीं देखें, हमें मुआवनत चाहिए ना, कि अच्छी बात है कि आप माशाल्लाह सीनियर वकील, हम वी वर लुकिंग फॉर सम सीनियर काउंसिल टू कैनवस द अदर पॉइंट ऑफ व्यू एज वेल, सो वी कैन अंडरस्टैंड इट प्रॉपर्ली। खैर, आपने सारी बातें तो सुन ली, आप बैठे हुए थे ना सुबह से? नहीं सुन ली ना सारी बातें। हम आज अजर्न करेंगे, अब तो 3 बज गए, तो ये लोग भी आ जाएं, शायद इनके लिए कल मुश्किल हो आना, परसों पे रख लेते हैं फिर ये केस। ठीक है। और अगर आप कोई एनीवन कैन सपोर्ट, आप किसका नाम तजवीज करें जिसको हम माइकल बना दें, क्योंकि दूसरा कैनवस करे व्यू पॉइंट। माइकल्स तो खैर न्यूट्रल होते हैं, मगर क्योंकि वी हैव द सीनियर काउंसिल हियर ऑलरेडी, द प्रेसिडेंट इज हियर, मिस्टर मखदूम अली खान इज हियर, सॉर्ट ऑफ नंबर ऑफ अदर अटॉर्नी जनरल इज हियर, आप भी इधर हो। सिद्दीकी साहब हो सकते हैं।
किसी केस में तो नहीं अहमद या सलाउद्दीन।
Case, Mr. Munir Malik was amicus.
He was amicus then.
We saw these. There were a number of Mr. Asma Jahangir was there.
Munir Malik was amicus then.
Whether he will be, how well he is.
In Samiullah Baloch.
No, but I thought the respondents would be opposing this. The respondents in these cases would not be opposing would be supporting the lifetime ban.
Mr. Maktoum Ali Khan, you won everyone over.
All the respondents are now against the lifetime ban. I don't understand. So who?
In fact, my lord, the opposing side, they were initially were of the fact that it must be a lifetime. Prior to that, in 2018, we are those who are making out that we should not be given a lifetime here for the 5 years. So only one thing is this, my lord, the whole scenario, I want to just add one thing, that is that a declaration and the conviction, these are the 2 words which are very necessary to be adjudicated by this honorable court. The one thing is this, that the conviction which has been maintained by any criminal court, that has to be given a kind of the seal of legality may be coming from the Election Commission of Pakistan, because in that the original trial court has to send the record of that case to the commission, so that afterwards that can become into the force through the legality, that next time अब एक आदमी को सजा हो गई, एक आदमी को for 2 years under 199 200 of the RUPA or the now present Election Act, or under 471, that conviction will thereafter be sent to by that court to the commission, Election Commission. The Election Commission will then going to file a complaint against the.
आप मुख्तसर बात करें ना, आप अपनी तकरीर कर रहे हैं, कुछ बता रहे हैं क्या आप कहना चाहते हैं?
1F की जो प्रोसीडिंग स्टार्ट होंगी वो इलेक्शन कमीशन की कंप्लेंट से स्टार्ट होंगी, मैं ये कहना चाहता हूँ।
इसका फायदा क्या इस बात करने का?
ये फायदा है कि
बगैर सजा के आप कहते हैं कि बगैर कोर्ट के कन्विक्शन के आप कहते हैं कि डिक्लेयर किसी को नहीं किया जा सकता।
नहीं सर, नहीं, कोर्ट जो इलेक्शन कमीशन को फिर भेजेगी और वहां से कंप्लेंट,
इलेक्शन कमीशन की कंप्लेंट पे हो सकता है, ये आप कह रहे हैं।
62(1)(f) के ऊपर
पोस्ट कन्विक्शन।
जी सर।
सनाउल्लाह बलूच साहब, ये देखें बहुत पेचीदा आईनी कानूनी मसला है। यकीनन आप पार्लिमानी मेंबर रहे और अच्छी तरह से आइन को समझते हैं, मगर हम आपको मौका देते हैं कि अगर आप कोई वकील करना चाहें, क्योंकि आप सपोर्ट कर रहे हैं ना लाइफ टाइम बैन को, तो क्योंकि ये इसमें ज़रा हमें तशरीह करना होगी, तो ज़रा यकीनन आपकी महारत है, पार्लिमानी महारत, मगर ये ज़रा बहुत टेक्निकल इश्यूज भी हैं, तो हम आपको एक मौका भी देते हैं कि अगर आप किसी वकील को करना चाहें, आपकी मर्जी है तो आप कर लीजिए। ठीक है, हम आपकी बात हम नोट कर ली, मगर वो देखें फिर हमने जितने बहुत सारी आर्गुमेंट डिस्कशन यकीनन आपने सुने होंगे, तो आप अगर कोई करना चाहे वकील हम कर लें, तो हम परसों पे फिर इसको रखते हैं, परसों केस 11:30 बजे।
मैं सर इसमें
CMA first application RO has rejected my nomination papers on the ground that disqualification is perpetual and for life.
इसीलिए तो हम चाह रहे थे ना वंस एंड फॉर ऑल सुप्रीम कोर्ट बैठ करके ये तयन कर ले, बिकॉज एक आरओ कुछ करेगा, दूसरा आरओ कुछ करेगा। अच्छा मिस्टर मखदूम अली खान, वन अदर इशू
My lord.
One is, you know, you win all or lose all. One is the middle way. The middle way is that Al-Samrez was, the law undid its effect. Can we have the list of those cases where a non-obstante clause, irrespective of anything held in a judgment, and they were sustained? Because that could be the middle way, that we don't touch the judgment, but now that the law has come, it occupies the legislative domain. This is one aspect. The other aspect which has not been touched upon is that we have only read the constitutional provisions so far. Most of these cases deal with the earlier election laws, which was ROPA, Representation of the People's Act 1976. Did that law or the Election Act of 2017 provide any term for disqualification, or it simply reproduces the language of the Constitution? Because I'm familiar with ROPA, I'm not so familiar with the subsequent enactment of 2017. So if you can consider those as well, that does the law say anything at all? And the third thing which I want you to attend to is, did either law, ROPA or the Election Act of 2017, prescribe a period of disqualification which was not mentioned in either 62 or 63? Are you clear with the queries?
Yes, my lord. Yes, my lord.
And these, for everybody else as well, these queries they can attend to.
My lord,
and I will request any of my colleagues, if they want to put a particular query, that you all can come prepared on that.
My lord, with one request and leave of your lordship,
ये डॉक्ट्रिन ऑफ लेजिस्लेटिव रिपील के ऊपर आप थोड़ा
जी सर, उस पे यही मैं रिक्वेस्ट करने लगा था चीफ जस्टिस साहब से कि those bundles are also ready, that list is ready. Your lordship will have to allow me to file a couple of more bundles.
मैं समझा नहीं.
You're wasting a lot of paper.
नहीं, which bundles?
वो सब लिस्ट ऑफ केस लॉ मैंने बनाई हुई है.
ये सबके लिए बना दें.
जी सबके लिए, अभी भी सबके लिए.
हमने आपको नैब केस में भी कहा था कि आईपैड्स दे दें हमें, सेव पेपर.
मलॉर्ड, इस इशू पे एक्चुअली मैंने ऑलरेडी पेपर बुक्स बना ली हैं, वो वैलिडेटिंग जो क्यूरेटिव लेजिस्लेशन के ऊपर केस लॉ है, मैंने ऑलरेडी.
तो आपको चलिए एक दिन का मौका मिल रहा है जी. अगर कोई और क्वेश्चन एनी ऑफ माय कलीग्स वांट टू आस्क, no, not you, आई एम सेइंग, I'm requesting my colleagues
very serious question of
ready with these queries.
Briefly, my lord, the citations are already there in the CMA which I have filed, but these will be submitted separately as well. As your lord.
Please attend to the question of repentance, which Samula Baloch specifically records.
My lord, yes.
तो ये जरा आप वो भी आप जरूर देख लीजिए.
मलॉर्ड, एक बड़ा सीरियस क्वेश्चन ऑफ लॉ है इन्हीं अपील्स में, जो जिस पे आई वुड रिक्वेस्ट माय लॉर्ड्स टू आल्सो एडजुडिकेट, एंड दैट इज व्हाट इज द इफेक्ट ऑफ सस्पेंशन ऑफ सेंटेंस ऑफ अ कन्विक्टेड पर्सन.
Is it one thing we've already noted in our original order, which was a 3-member bench order. Of course, if my colleagues want to add to it, that we will stay clear of criminal cases, pendency. We are just going to restrict on qualification and disqualification because elections are.
इससे इसका इस केस से तो नहीं ताल्लुक.
My lord, वो judgment उसके अपील में मैं आया हूँ और वो sustain हो नहीं सकती because that judgment is in violation of a number of judgments of the Supreme Court. वो judgment basically उसका effect ये है.
हम principle of law तयन करना चाह रहे हैं. Individual cases हो सकता है हम उनको अलग कर दें, फिर सुने, छोटी बेंचेस सुने. ये 7 मेंबर बेंच अगर सुनने बैठ जाए तो पूरे इलेक्शन खत्म हो जाएगा. हम सुनते
सिर्फ प्रिंसिपल की मैं बात कर रहा हूँ. वो उन्होंने रिडंडेंट कर दिया है आर्टिकल 63(1)(h) को, जो हमने अभी
बात में सुन लेंगे. आपको
आपने जो कंसाइज स्टेटमेंट दिया, नंबर क्या उनका?
माय लॉर्ड, उसका मेरा नंबर है जी 8, CMA नंबर 8 है माय लॉर्ड. और इस पे केस लॉ भी माय लॉर्ड मैंने सारा जो मैंने कोट किया हुआ, मैंने उसकी पेपर बुक्स भी बनाई हैं. माय लॉर्ड
आपकी CMA कौन सी?
Mine is 6, my lord.
So what we do today, we'll observe loudly, and that I'm sure will be recorded. If anyone wants to canvass the contrary point of view, not to come and make a speech, but attend to the constitutional provisions and the law, we are ready to hear it. The contrary view being that it's a lifetime ban. So because most of you are in support of a 5-year ban or no ban at all. So that offer is open to everybody. If we consider, we will appoint amicus as well, but at short notice, whether they can render even that assistance or not, because this has to be wrapped up very quickly one way or the other, because every returning officer should not be left confused what he has to do. I'm sure you all agree to that extent. Whatever it is, it should happen once and for all.
And my CMA number 1 for stay is fixed today. Regarding the RO in civil appeal number 1946/2023,
will be disqualified.
My lord, RO has held that he is disqualified for life, regardless of section 232(2) and regardless of orders passed by my lords.
नहीं तो हम देख लेंगे ना. अभी हम
अपील में जाएंगे ना.
अपील तो कर लेना अपनी राइट्स ऑफ.
As an abandoned caution, we have.
हाँ तो वो कर लीजिए ना. पता नहीं हम किस तरफ फैसला करें. अगर हमने आपके फेवर हो गया तो उसका इफेक्ट हो जाएगा ऑटोमेटिकली. ठीक है.
I had drawn your attention to the 4 points which Ishaq Akwani's case the court had left open with regards to which court would it be to give the declaration, the procedure to be followed, the standard of proof and the locus standi. It is PLD 2015 Supreme Court 275 at page 283. These 4 issues are identified but were left unanswered. So if my lords, and this is also for posterity because this declaration of law, now we are looking at the time limit which is to be applied to this declaration of law, but how this declaration is to in fact be given is also something very important. 2015 Supreme Court, PLD 2015 Supreme Court 275, Ishaq Akwani versus Mia Nawaz Sharif, and page 283.
I will do it at 9:30.
Paragraph 4.
In a judgment, my lord, in Roshan Ali Brero's case, your lordship has also raised that similar question while dissenting, my lord. That question is still parked, my lord. Which one? It is appeal to the future, my lord.
2019 as CMR.
Yes, this is 2019. This is, my lord, 2019 as CMR 1939. 1939.
So appeal to the future. Are we the future?
Yes. So now is a good time, sir.
चलिए इसमें लिखें फिर.
या आपने भी अपील टू द फ्यूचर कर दे.
अच्छा हाँ इसमें लिखिए CPLA number 2680/2023. The point raised in this petition are the same as are being considered in the cases in Civil Appeal 981/2018 and other cases fixed before the 7-member bench. Accordingly, this case to be fixed along with the said cases as well. Full stop. The number. अच्छा ये हमें एक चीज भी बता दीजिएगा ये हमें बिकॉज there should not be created an impression which unfortunately we cannot control, social media or even media, but for accuracy's sake, who is contesting which political party. So let it not be perceived as this is for a political party or against a political party. We are only concerned with the constitutionality and the legality of the matter. So I really don't know these names, whether they're independent candidates or their things. So if someone can give us a list of who's where, so that would be helpful and may dispel the notion that it is for a particular cause, which is not our concern in the least. क्या लिखा है? हाँ, इसमें लिखिए the learned Attorney General and the Advocate Generals of the provinces state that they support the constitutionality and legality of Section 232 within bracket 2 of the Elections Act. There is an S. Elections Act 2017. Full stop. A number of petitioners oppose कौन कर रहा है? आप. Most of the petitioners most of the council representing petitioners appellants applicants support the contention of the learned Attorney General and the Advocate Generals, whereas आपका नाम लिख दे in CMA CP 684 और कौन अपोज कर रहे हैं? आप
880 CA 880
नाम अपना बताएं. नाम बताइए.
खुरम रजा मैलम.
मिस्टर खुरम रजा and Mr. Khuram Raza in
CA 880 oblique 2015
states that the lifetime it should that it is a lifetime ban. अच्छा, सब्जारी साहब भी का नाम पहले लिख दें. सीनियर काउंसिल है ना, सीनियर काउंसिल का पहले नाम लिख दें. सब canvass the contrary viewpoint that it is a lifetime ban. Full stop. A number of council are appearing from other stations through video link, and they are requested that in view of the constitutional importance of the matter, it would be better if they are in attendance at Islamabad so that their submissions can be properly heard and understood. Full stop. We also welcome any senior counsel who wishes to assist this court to do so with precise constitutional and legal submissions supported by applicable case law. लगता है कि अगर हम कोई माइकस अपॉइंट करें शॉर्ट नोटिस पे, पता नहीं इट विल बी फेयर टू माइकस और नॉट. कैन यू सजेस्ट अ नेम दैट वी कैन अपॉइंट इन हु इज अवेलेबल एट इस्लामाबाद और पिंडी? कलवे हसन साहब एक सीनियर वकील हैं, और कोई और अगर आपको कोई
इस्लामाबाद दूसरा आना चाहिए ना.
आई डोंट नो व्हाट
फॉर्मर जज ऑफ हाई कोर्ट लाहौर
या मौजूद कोई इस्लामाबाद पे. अब हम उनको लाहौर से बुलाएं किसी को?
इस्लामाबाद में होते हैं.
कौन?
पिंडी में होते हैं.
कौन?
मौलवी अनवारुल हक साहब.
हाँ,
मौलवी अनवारुल हक साहब.
ठीक है, इन दो को करने हैं.
My lord, he is not enjoying very good health these days. He's having issues with his health lately, my lord. Maulvi Marullah.
नहीं, हम ऐसा करें, हो सकता है हम अपॉइंट कर लें जरा, बिकॉज वो कह रहे हैं उनकी तबीयत ठीक नहीं है. But anyways, if someone wants to come and assist on a legal point, even if they're not parties, they may come and do so. Sanaullah साहब को हमने already कह दिया. Mr. Sanaullah Baloch states that he represents his brother Samula Baloch and supports a lifetime ban. However, since since we are adjourning the matter, he is granted an opportunity to engage counsel if he elects to do so, or be properly authorized by his brother. ठीक, adjourn to परसों की तारीख दे दें, जुमेरात की at 11:30. ठीक है, अच्छा, we are planning to conclude on 11 January. So that be precise as far as possible, and those questions we will not reproduce in the thing. We will just leave it like that. Anything anyone wants to add?
My lord, only this, that if your lordship is willing to consider as far as Karachi, then Mr. Faisal Siddiqui can be a choice.
That's the name that we're thinking.
Yes, Mr. Salahuddin Ahmed, Faisal Siddiqui.
Salahuddin Ahmed, Mr. Faisal
Unless they're in one of these cases.
Ji.
So we will
check with them.
We will just we may add some micros.
आपको बता रहे हैं सुप्रीम कोर्ट में ताहयात नाअहली केस की बराह रास्त समाअत इस वक्त जारी है और चीफ जस्टिस की सरबराही में 7 रुकनी बेंच इस केस की समाअत कर रहा है। आज का हुक्मनामा लिखवाया जा रहा है। इस वक्त आपको बराह रास्त इस समाअत के मनाज़िर भी दिखा रहे हैं और चीफ जस्टिस की जानिब से कहा गया कि मामूली वजूहात की बिना पर नाअहली गैर मुनासिब नहीं लगती।
My lords may also then consider Mr. Ashtaraz Saaf Ali because he had a certain he was the Attorney General when this case was argued.
That view is already there.
I know. But we were looking for the alternate view, the other view.
We need opposite view.
ठीक है, थैंक यू।
वो आप ऑपोजिट व्यू ही देख रहे थे तो मैं इस कंटेक्स्ट में कह रहा हूँ।
चलिए, थैंक यू एवरीवन।
थैंक यू मैम।
सुप्रीम कोर्ट में ताहयात नाअहली केस की बराह रास्त समाअत जारी है और इसका फैसला भी लिखवाना शुरू कर दिया गया है। समाअत अब जुमेरात तक मुलतवी कर दी गई है। आज की समाअत का ऑर्डर लिखवा दिया गया है। समाअत जुमेरात तक मुलतवी कर दी गई है। चीफ जस्टिस ने कहा कि मामूली वजूहात की बुनियाद पर नाअहली गैर मुनासिब नहीं लगती। इस्लामी मयार के मुताबिक तो कोई भी आला मयार का मालिक ठहराया नहीं जा सकता। क्या जजेस को घर भेजने वाला, आइन शिकनी करने वाला अच्छे किरदार का हो सकता है? अभी शामिल करेंगे न्यूज हेडलाइंस।
कत्ल और गद्दारी जैसे संगीन जुर्म में कुछ अरसे बाद इलेक्शन लड़ सकते हैं। मामूली वजूहात की बुनियाद पर ताहली गैर मुनासिब नहीं लगती। चीफ जस्टिस काजी फाइजीसा के ताहयात नाअहली केस में रिमार्क्स। कहा कि एक मुसलमान सादिक और अमीन के लफ्ज़ आखिरी नबी के सिवा किसी के लिए इस्तेमाल कर नहीं सकता। अगर ये तमाम शराइत पहले होती तो कायदे आज़म भी नाअहल हो जाते। इस्लामी मयार के मुताबिक